Obviously, I can't comment on the acceptability, but wanting to reinforce that this is a very significant impact upon residential amenity.
Yeah, I had trouble with...
Yes, we're in agreement.
I was going to take you to viewpoint 11, but I think having done it yesterday, there's no need, so I'm going to bypass that. We know we're apart. In summary, therefore, in terms of the geographical extent of significant visual effects, it might be useful to get out, please, Kelly Anderson's table 8.1, which is at internal page 33 within her inquiry report. No need to go to it, but just rehearsing for the reporter's benefit, in 832, Kelly Anderson summarises her views of the geographical extent of significant effects to be within 5 or 6 kilometres. I'm not saying you agree that, I'm just asking the reporter to note that evidence. Let's look at that table 8.1, and let's first see how it works so that when we go to it, we know what we're talking about. Obviously, the viewpoint, the left column is obvious, location, distance. Now, that scale of visual effect is, of course, Kelly Anderson's finding in the LVIA of the, or indeed in her inquiry report if it's changed, of the magnitude of effect. Then we've got who the receptors are, but the final two columns are the two new columns for the purposes of evidence to the inquiry. And they go beyond the LVIA because she deals in terms of magnitude of change and significance. I think we're reading it the same way, aren't we?
Yes, we are.
That's fine, so we know what we're looking at. Now, we, I think, are in agreement, trying to cut this short, for viewpoints 1 to 5, they're significant. That's, I think there's no need to answer that. We know that's the view. So the first point I want to go to is actually viewpoint 5, because if you go to the statement of agreed matters, and I mean the current one, not the November one, and you go to paragraph 512, or perhaps actually at 511, the parties agree with the extent of significant visual effects identified in the LVIA and listed below. Acceptability is disputed, and then there are 2 bullet points, the receptor group at Heriot, etc., and bullet point 2, which we can read for ourselves. But then there's a paragraph which was added by Scottish Borders Council. The visual effects are disputed in terms of significance levels and likely significant as follows. Receptors are on the A7, done that, not going back there. But turning the page, viewpoint 5 at Netting Flat. I'm not sure it is disputed, is it? Because you agree it's significant. Kelly Anderson agrees that would be a significant effect.
Yes, I think that is now in agreement, and we welcome the upgrading of those level of effects from the earlier.
Hang on. This insertion by Scottish Borders Council post-dated both the inquiry report and the precognition. So I'm asking you to accept that contrary to what has been inserted there, in fact, the viewpoint 5 significance is agreed. Yes?
Yes, I would agree with that.
Thank you. Turning to viewpoint 6, which is the B7007, Kelly Allison does not find that to be significant. In your review at paragraph 417, you record what the LVIA says, a medium magnitude, whatever. You don't conclude on significance, but it would seem from the statement of agreed matters that you agree that that effect would not be significant.
That is correct. It's just referred to later on in terms of cumulative effects for potential significance.
I understand. Yeah, thank you. For viewpoint 7, Kelly Anderson says the effects would be significant. The statement of agreed matters doesn't really cover that viewpoint. I think, but you both say that effect would be significant, don't you?
Yes, as before I said, I thought it was likely significant from the information given.
Okay, I understand. Viewpoint 8, Kelly Anderson says not significant. From the statement of agreed matters, actually is covered in the review at paragraph 419. You strongly suggest a change from small to medium. Do you say that's significant?
No, I'm not suggesting that's significant, just greater effects than recorded.
I understand, thank you. You don't assess viewpoints 9 and 10 at all, do you?
I think viewpoint 9 is very screened and evidently not a significant viewpoint. And viewpoint 10 also, I didn't view that on the ground, and it didn't appear to be one that I was expecting to be likely significant and further interrogated. That's
all right. Thank you for that. We know where we are on viewpoint 11, needn't go there. Viewpoints 12 to 17 have not been assessed by you, nor indeed are they included in Table 1. So I think we probably, though, agree that between viewpoints 11 and 17, there were no claims of significant effects. Is that correct?
That's correct, and I only drew attention to viewpoint 17, which is scored law, in terms of potential for increased effects, but not significant
17?
Effects. I think it was 17.
18, I think. It is 18, I think.
18. Apologies.
That's all right.
18.
Ma'am, can I just raise a point that concern? It's not about this witness's evidence, but it's about what Mr. Trinick's saying about his witness's evidence. My understanding was that his witness didn't form and agreed she didn't form a view to significance at any viewpoint. She formed views as to significance as receptors to receptors. So there's a clear difference between the two. And I understand my learned friend may be using it in shorthand. If he's using it in shorthand, then I have no objection to making progress. But I just didn't want that to pass uncommented upon, so that I can understand what case I have to meet when drafting my closing submissions.
No, thanks, Mr. Findlay. Mr. Trinick, could you perhaps could you either tell us if that is the case and it is simply an abbreviation in your text, or is it as Mr. Findlay might think?
Well, I take Mr. Findlay's points in terms of the LVIA, but actually in the inquiry report, in Table 8.1, is where Kelly Anderson takes matters beyond the LVIA and actually does find whether or not the effects at viewpoints are significant. So she has given evidence on significant effects at those viewpoints. I'm using her evidence very directly.
I have to say that is entirely contrary to the answers she gave me yesterday, because I put to her specifically she didn't form views as significant at viewpoints, but as to receptor groups, where the viewpoints were used to apply or supply the scale of change. We can review the recording if necessary to deal with that. But if the evidence is now being presented that this is a specific assignation of significance at viewpoints, I can comment on that change in closing.
By all means, and I'm sorry if you received the impression yesterday that Kelly Anderson continues not to find significant effects. I think she may have thought you were cross-examining her on what was in the LVIA, but in her inquiry report, it's very explicit indeed in that table. Indeed, she explains exactly what she's done. She's gone beyond the LVIA and found significance of the viewpoints. The evidence is there in black and white.
Again, Mr. Chairman, with respect, I'm wrong. As I understood Table 8.1, it was meant to be a summary of what had been described before. And in what's described before, she goes through various receptor groups and makes clear findings of significance or lack of significance from 8.2 onwards, where she refers to the viewpoint as illustrative or otherwise. But my understanding, and she, in answer to me, confirmed various changes from the LVIA judgments in that regard, such as at 8.2.10 at the end of that, and likewise at the end 8.2.12. So, frankly, I wasn't asking her about the EIAR, I was asking about her evidence, and that's how I understood Table 8.1. Given Mr. Trinick's comments, we can review the evidence Ms. Anderson gave yesterday, and if it's inconsistent with how Mr. Trinick's now putting the case, I can comment accordingly. But there was no re-examination on her evidence on that part.
Perhaps because I did understand you were examining about the LVIA. Paragraph 831 of the inquiry report says, in order to assist the inquiry in comparing the assessment of visual impacts with those in the Council's landscape officers' consultation response, the report of handling, and Nature Scott's consultation response, as well as any amendments to the visual effects presented within the LVIA, below is a summary table which correlates the viewpoints and the visual receptors assessed by Stevenson Halliday. And in that table, you can see that she comes to effect and significance in the right column. And if there's a misunderstanding in cross-examination, obviously you must make your comments in closing submissions or raise the matter with Mr. Kelly in evidence. But as far as I can see, there's no doubt that that's what she has done in Table 8.1. I'm sorry if we differ, but there we are.
Again, just to say, take viewpoint 3, she's given three separate descriptions of receptors and 3 separate findings of significance depending on the receptor group she's considering at that viewpoint. And so, for instance, in taking into account the A7, her findings of significance aren't as to the A7 at that viewpoint, but the A7, as she explained yesterday in evidence, taking into account the extent of the A7 which is affected. So, with respect, Mr. Trinick, I disagree, but we can deal with that in closing submission.
Well, I think we do disagree, but we can't take it much further. For the reporter's note, we are categoric that what Kelly Anderson has very clearly done on Table 8.1 is, as I rehearsed with the witness just now, in cross-examination. And the witness appeared to find no difficulty in accepting that's what the table did. So I don't think the witness is being in any way misled at all.
I think I can understand the confusion and the points, and it does appear to be a move onwards from what the LVA has assessed. I can't comment on how that appears in terms of cross-examination.
No, of course you can understand that. But Table 831, that's paragraph 831 plus the table, As far as we're concerned, and I don't want to go back in a circle with Mr. Finley on this, I respect his view, it's quite clear, ma'am.
It's clear to me. My recollection is similar to Mr. Finley's yesterday, but I do take your point that Table 1.8 correlates the assessment of the receptors with the viewpoints as set out in the EIA and LVIA. Mr. Finley, are you content to address this further if you wish to do so when Mr. Kelly gives evidence?
Yes, I mean, it's not really a question for Mr. Kelly. It's a proper understanding of Mr. Trinick's witness's evidence. And I'm glad that your recollection, my recollection is consistent with yours. But I can deal with it in closing submission. It's I wasn't objecting to the cross-examination. Sure. I think I made that clear. I wasn't suggesting, contrary to Mr. Trinick's comment, that he was misleading the witness. All I wanted to know was to understand how the case was being put. I now understand how it's being put this morning and can comment on the difference between that and yesterday.
Thank you, Mr. Finley.
I'm grateful, thank you.
Mr. Trinick, you could resume.
Turning to viewpoint 18, if you look at your review, first of all, at paragraph 421, you record the finding of negligible and say, however, this is potential for medium scale. In viewpoint, sorry, not viewpoint, inquiry report 5.7, you deal specifically with this viewpoint and say on the second line, first line, the determination for this viewpoint is contested with a likely increase from the assessed level of negligible to a likely medium scale, although not reaching significance levels, the distance from the proposed development at 22.9 km, etc., illustrates the potential reach of moderate level impacts. Now, you don't rehearse the viewpoint in your precognition, but if we go into the statement of agreed matters, in paragraph 5.12, you now appear to be contradicting what you said in your inquiry report and are claiming significance at viewpoint 18. So what is your evidence?
I think, are you reading that in terms of visual effects disputed in terms of significance levels and likely as follows? I think more strictly disputed in terms of significance levels or in terms of adverse effects levels rather than significance levels.
All right. So are you sticking to what you said in your inquiry report, that although not reaching significance levels, so not being
Yes, that's the evidence.
not significant?
Yes, I'm not claiming there's a significant impact to that extent, but I thought it was important to illustrate how far the fairly moderate, they're assessed as medium scale visual effects reach at that distance.
Have you visited viewpoint 18?
No, I've been clear that I didn't visit viewpoint 18.
matters. You see that?
I do see that, yes.
But then we have 522, the acceptability of a small number of determinations within the RVAA are disputed between the council and the applicant and may reach the RVA threshold. I'm not surprisingly confused as to the position of the council. You say may reach. Do we strike 521 and just read 522 as being the current position of the council? What do we do?
I think that particularly with the new evidence provided and the on-site conditions, that the current position will be that there may be some properties which do reach the level.
I don't quite understand the answer. What has changed? Say on-site conditions, they are as they were in November.
They have changed since the original assessment and the original, because of the tree felling and because the habitability of one of the properties was changed since the original RVAA.
So those two factors are...
Yes, that's correct.
And the evidence for the council...
I think that the discussion needs to be had as to whether that the RVAA determinations are correct.
I'd like an answer to that. My question, really, I want to get clear what the Scottish Borders Council evidence is. I think from 522 you're saying that the acceptability of a small number of determinations are disputed and may, not will, may reach the RVA threshold. Does that accurately summarise the views of Scottish Borders Council?
I think in as much as the discussion needs to be had, it summarises the views of the council's position.
You say in as much as discussion needs to be had. Well, it does. That's the point. It's quite an important topic. And we know it's disputed with Heriot Council. But as far as the Scottish Borders Council is concerned, I want to be absolutely clear that you are not saying there will be residential amenity effects. It will reach the threshold. The answer is it may. Is that correct?
Yes, that is correct from the council.
Thank you. I'll leave residential amenity there. Doubtless come back to it. Heriot Council. Designated landscape, very brief. Look at your review at paragraph 4.6. Your point of concern in 4.6 to 4.9 is really Fallamore on a cumulative basis. That's correct, isn't it?
Yes, on a cumulative basis.
That's fine. Probably there's not much point in cross-examination further, because if we go to your inquiry report at paragraph 4.3, and looking at the effects of Greystone now on the operational and consented baseline, no designated landscapes will encounter significant adverse effects. So that's agreed between us, isn't it?
In terms of the operational and consented baseline?
Yes.
Yes.
That's correct. Right, we know where the dispute is there, that's fine. Going on to cumulative effects, give evidence in chief on a position resulting from the Woolmuir decision, and I understand what you say, but in terms of the position you recorded in your inquiry report and then the review, nothing has changed in the sense that Woolmuir was in the baseline. In other words, you've already assessed Woolmuir as if it had proceeded. It simply changed its status, that's all.
Right. Oh, there we go. Yes, so it was assessed as a in-planning scheme, and it now forms part of the consented schemes.
Yes, absolutely. Sorry, yes, absolutely. My point was this is not something new which has happened, which changes anybody's assessment, because Woolmere was already in the assessment.
I think that's correct, although in terms of the distinction you made before in terms of assessing the in planning and scoping schemes, it does switch into the current baseline of consent.
Absolutely. No, I understand that fully. No, I do understand that. That's fine. Just a question. When you look at cumulative effects, if you look at, say, doesn't really matter, paragraph 6.3 of your inquiry report, this is under the heading of cumulative effects. When you're looking at Falla Hill area, that visual receptor group, and all the other groups, let me preface the question with this. There are two ways of looking at cumulative effects. Look at the additional effects on any given baseline. What does Greystone now add to the existing effect? You can say and look at the overall effects, the in-combination effects, i.e. the whole picture, as the incremental effects. There are two ways of doing it. We understand that.
Yes, I understand that.
Which way are you looking at it in your evidence? I couldn't quite... It would seem to me you were looking at the combined effect.
No, I was trying to work from a basis of looking at the cumulative effects in terms of the baseline and then the introduction of Greystone now into that baseline.
So you were looking at the additional effects,
The additional effects of Greystone now being introduced.
Do you look at the combined effects at all? Or
I think I did include a quick summary of the combined effects.
where is that? I'm not saying you don't, I just want to know where it is.
No, I think you're correct. I've just included the additional effects.
Okay, that's fine. And in terms of the, if you look at paragraph 6.1 of your inquiry report, and at the first sentences, cumulative effects within CLVIA are determined to have no greater impact other than localised situations than the impacts identified for the proposed development. This is when compared with the operational under construction. So I think
that was the case, but since Woolmere, that's obviously changed.
that changes things. I understand that. Ms. Platt, thank you very much. Those are my questions.
Thank you.
Oh, yes.
Right, thank you both, Mr. Trinick and Ms. Platt. We move to Scottish Borders and Ms. Thompson. Do you have any re-examination?
No re-examination, thank you.
Okay, thank you. I did have a question for Ms. Platt, but it's actually in relation to the extent of your assessment of significance on the A7, but Mr. Trinick preempted me this morning, and I'm satisfied with your answer. Thank you very much for your evidence, Ms. Platt. So, in accordance with our inquiry agenda, and giving everybody a moment to organise themselves and their papers, we will move to Heriot Community Council and others, and to Mr. Absolutely.
Right.
Mr. Campbell, could you begin your evidence in chief from your witness, Ms. Platt?
Thank you. Good morning, Ms. Platt. On behalf of Heriot Community Council, could you have in front of you your inquiry precognition, please? I'd just like to, in this document, you reach or you express certain judgments and opinions. I'd just like to see where, if any of those changed, or whether you're happy to abide by them. I'll try and do this quickly. The overall conclusion at 2.2, are you content with that?
Yes, I'm content with that.
Thank you. At the bottom of page 1, going on to page 2, in paragraph 2.3, you say the siting and scale is evidently not determined by any recognition or desire to subdue or mitigate harmful effects overspilling into this character type, which is plainly unsuited to development of this size. Effects on landscape character are anticipated to extend at higher levels into LCT 91. Now, by this character type in that sentence, can I just be clear that you're talking about the Gala Water Valley?
Yes, that's correct, into the valley area, which is LCT 114.
Yes, thank you. If you would turn to 3.1, or read on to 3.1, please. You say that the applicant's expert, you do not agree with her conclusions. I would not characterize them as properly objective or measured having regard to actual conditions on the ground. You go on to explain why in 3.2. And then from 3.3 to 3.5 in relation to landscape, and 3.6 in relation to visual effects, 3.7 in respect to residential impacts. I don't want to read each of those aloud. I'm sure the reporter's had a chance to do that probably many times, but are you content with the conclusions that you reached there, please?
Yes, I'm content with those.
Thank you. Just one question about 3.7 in detail. In the second sentence, you say, I regret I cannot agree, in particular with regard to Wester Corsop and Upper Corsop Cottage. By using the words in particular there, are you confining the evidence to those two properties, or are you suggesting that there might be wider effects which cross the threshold?
I'm relating that in particular to those two properties in terms of being confident that there's a high likelihood that they would reach the overbearing effects, but that it's also close to the threshold with Corshope House as well. And there is a discussion to be had regarding Fountain Hall and whether properties within that area would also reach the threshold because they've not been assessed.
Indeed. You elaborate on this at 3.8, excuse me, and you say in the second last line, the introduction of the proposed wind farm will become the dominant and defining feature with these properties adjacent to and sitting within a highly developed context. And that's quite a strong use of language. You're happy with that, still, having heard the evidence?
Yes, I think on visiting those properties, it's very evident that the wind farm will be, as I say, a dominant feature and will be seen from many of the views and from the curtilage of the properties. And it was difficult to believe that it wouldn't be an overbearing effect.
Double negative there. It's difficult. Try that again for me, please.
I found it difficult to believe. I felt that there would be overbearing effects from those properties.
Thank you. Sorry, it's a preoccupation of mine, double negatives. Go to 311. In the last sentence you say, although it's accepted that large-scale wind farm development may result in often significant landscape and visual impacts, I regret I'm not able to agree that in this case they would be properly classified as localised. And there's a passing reference to the policy, which I won't trouble you with. What are the determinants which would enable you as an expert to describe an effect as localised or otherwise?
This was a little bit of discussion yesterday, and I think my conclusions relating specifically to this scenario, bearing in mind that localised effects are calculated in different ways, was that when moving within the landscape types, it feels that there are enough transitions that you move away from the local area but can still feel the effects once you're beyond what feels like the local landscape context. So the 8.6 kilometres relates to viewpoint 11 at Lauder Common, which is a good measure for potential effects onto Lauder Common area, and the potential for visual effects to reach that extent and for cumulative significant landscape character effects also.
Mr. Campbell, could I ask you to put your speaker on when you are speaking?
Yes, I forgot the last time, I'm sorry. In 4.6, in the first line, you've used the expression highly adverse. I'd like to understand if you intend us to detect a difference between highly adverse and adverse.
I was just stressing the high numbers of high determinations from the RVAA itself, and that those should be taken into account and considered strongly.
Those are all the supplementary questions I have in evidence in chief. May come back later, of course, if anything arises out of cross. Thank you. You'll have to stay there, I'm afraid, for a little while.
Thank you both. In terms of cross-examination, Mr. Trinick, could we start with you if you have any additional questions for Ms. Platt?
I would imagine I'm the only person actually cross-examining Calder Platt, but there we are. I'm not going to ask you the same questions, Ms. Platt, as I did when you gave evidence for SBC. We covered that ground. This is going to be a very short exercise. And I'm not going to ask you any questions about whether or not an impact would breach the residential amenity threshold. That's such a subjective issue. It can only be determined by the reporter on site, taking into account the evidence of her own eyes and the evidence before her. So that would be a pointless exercise. I want, maybe uncomfortable, I want to look at the style of your precognition, mainly from wholly from paragraph 3. If you hear 3.8, first of all, perhaps a point of total confusion on my part. The properties in question are likely to experience effects of such magnitude to be overbearing. First of all, in your inquiry report, you only cover 2 properties. That's correct, isn't it?
Yes, that's correct.
And I think you give no evidence, except in answer to a question in chief just now, about any other specific property in terms of residential amenity.
Yes, I haven't detailed any more in the reports, but I felt it was worth reflecting on discussions yesterday regarding Fountain Hall.
Fountain Hall?
Fountain Hall being omitted from the 2.5 boundary.
Yeah. But you mentioned Corsope House today, which has not been assessed by Kelly Allison or indeed by you.
Corsope House is in the residential visual amenity assessment.
Yeah, you've not commented on Corsope House yourself in your evidence, have you?
No, it's not within my reports. No.
No. So the only 2 properties in respect of which the reporter has your written evidence are the 2 you cover in your inquiry report.
Yes, so that's Wester Corsope and Upper Corsope.
Indeed. And on behalf of Scottish Borders Council, you reached certain, I mean, you are a professional witness, so you reached certain views that the effects might cross the threshold. But for Heriot Council, you seem to be taking the view that they will cross the threshold. How do you reconcile your evidence for one party as opposed to another in that sense?
I think that the views of the community, which I'm trying to represent, are obviously stronger in terms of residential visual amenity than perhaps the council's views.
When you say you represent the community, you're here as a professional witness to help the reporter. It's difficult for me to see how your evidence for one party could be different from your evidence for another.
No, I'm clear. My evidence is the same, but I've put slightly more emphasis and more time into expressing for the community the views of the residents.
Well, I hear your answer, and that will go into my submissions, but I would expect the evidence that you give to be the same for both parties as a professional witness. You understand my point?
Yes, I understand.
All right. So in that paragraph 3.8, in the second sentence, this is what I don't understand. I just want you to understand what you're saying there. The replacement within Ms. Anderson's report of previous cited mitigation factors detailed to reduce these effects with alternative mitigation suggestions, the difficulty in arguing these properties will remain habitable. I have no idea what you mean.
So to clarify, I was referring to the original RVAA, which cites the woodland screening as part of the mitigation alongside intervening landform. In the re-review in Ms Kelly's report of the residential amenity of the 2 properties in Corsope Valley, the screening is obviously removed because it's been felled, and the intervening landform is again cited, but it appears difficult to argue that there will be suitable mitigation and screening on that basis.
So the mitigation factors... So the previously cited mitigation factors, that's the forestry, that's been felled. The alternative mitigation suggestions, that phrase means what?
That refers to the intervening landform.
Landform. Well, at least I understand it, and thank you for that. Go to your paragraph at 3.1. Given the very measured and professional nature of your review and your inquiry report, I was slightly surprised to see you characterise Kelly Anderson's evidence as not properly objective or measured. What do you mean by that?
I'm just referring to some of the determinations which we felt were stronger and more adverse than Kelly Anderson's.
Well, that's a matter of professional disagreement. Are you saying that her assessment has not been objective?
No, I was simply stressing that we disagree on some of the opinions.
Perhaps you'd like to withdraw that phrase.
Which phrase are you referring to, sorry?
Properly objective. Unless you're saying that Kelly Anderson has not been objective.
Sorry, I'm happy to withdraw that phrase, but
Thank
to
you.
stress that the issue was just to highlight the disagreements between determinations.
All right. What do you know of the lavender test? Are you familiar with it?
I'm familiar with the report and the summary and the idea
So
of...
what report and summary?
Sorry, the report concerning the lavender determination.
What report?
I can't remember the exact name of the report. I'm sorry, I haven't memorised it. But I have read it in the past. I'm aware of its existence and the
Do
principles.
you mean the Ennifer Downs case?
Yes.
I mean, it doesn't appear in your review, it doesn't appear in your inquiry report. It suddenly emerges in your precognition. I'm just surprised. You're saying you were familiar with it before?
Sorry, it's something that I'm familiar with, but as I say, I don't have the detail memorised to note, but I felt it was important to refer to it as in a basis in the report.
And tell me about your knowledge of Scott's practice when it comes to RVAA.
In reference to the Ennifer Downs and the lavender test.
No, I'm asking you about your understanding of Scott's practice in relation to RVAA.
I think that the determination in terms of using professional judgment and looking at whether residential amenity and overbearing effects are at such a level that they're likely to make a place an unattractive place to live. That would be my interpretation.
It makes me very uncomfortable, this. I read your review, I've read your report, they're in your style, quite clearly. The precognition just departs in style totally from the previous two documents. I'm going to ask you a blunt question. Did you write the whole of this precognition yourself without contribution from others?
I had some guidance and assistance in the layout of the proposal, if that's what you're suggesting.
I'm looking at some of the phraseology within it. The reference to Scott's practice, simply mimicking lavender test. This is not your language. Are you saying you really did write all those paragraphs yourself without help from others?
Oh yes, I did have help from others, as I've said, to formulate and to structure the report.
Yes, so you had help in writing this report.
In structuring and formulating the report and content.
I have to put it to you bluntly, I don't see your authorship in some of these paragraphs.
The report is by myself, but as I say, I've had help in making sure that the content is there and the structure is correct.
All right. Well, we'll have to leave it there. I can't take it any further, but you have my point, ma'am.
Yep, I was about to say, I think I understand both your positions. You could move on from that
Very well.
point.
Thank you, ma'am. Let's see. I have no further questions.
Thank you very much, Mr. Trinick and Ms. Platt again. Do any of the other parties wish to have any questions and cross-examination? I can see you both confirming you don't. Thank you. So I actually don't have any further questions for Ms. Platt. Mr. Campbell, I can revert to you for re-examination if you wish.
Thank you, Madam. There's no point in, there's no serious point which needs to be re-examined. So I have no questions.
Thank you very much. If we're all content, then that is the Harriet Community Council, and I imagine to as an expert witness on this, and is finished for today. Thank you for your contribution to our inquiry. at that point to the evidence on behalf of Rayshaw Farms. Thank you. See you back here at 11 a.m. Apologies. We will resume our inquiry into landscape and visual matters, and we will move to the evidence on behalf of Rayshaw Farm Holdings. Mr. Finlay, could I ask you to begin?
Indeed, I'm grateful. I call Ian Kelly, member of the Royal Town Planning Institute, and instruction on behalf of Rayshaw Farms, who provided a precognition which we'll take as read, and a report. And I have no additional questions to ask you, Mr. Kelly. So unless there's anything you would wish to add yourself at this stage, I'll tender you to Mr. Trinick's well-known mercy.
Thank you.
So, as Mr. Kelly doesn't have any additional points to make over and above his precognition and inquiry statement, we'll move to Mr. Trinick and his cross-examination. Thank you, Mr. Trinick.
Thank you, ma'am. Good morning, Mr. Kelly.
Good morning, Mr. Trinick.
You're appearing for Rayshaw Farms Limited, and I see from CD 14.1, no need to go there, that Rayshaw is the operator of farming and sporting land broadly to the north of Greystone now.
I've checked. I've checked. That's the extent of the estate is following further acquisitions is quite extensive. It goes from the north of the site along the western boundary of the wind farm and wrapping around the south side of the wind farm. So it basically wraps around 3 sides of the wind farm.
Thank you for that. And the owner of Rayshaw Farms is, I believe, a Mr. Louis Moore Bacon, is that right?
That is the ultimate
owner.
Yes.
And I'm not making any comment, I was interested. He owns a hedge fund in New York, he lives there, and
Really,
he visits
frankly,
occasionally.
no comment. He's just made it. It's got nothing to do with landscape and visual impact, whether he owns a hedge fund or not, as Mr. Trinick well knows. I mean, he can have his fun, but really.
It's not fun.
Noted,
Does he
Mr.
live
Finlay.
here? Does he live here? But another way.
Not permanently.
Not permanently. But Rayshaw Farms isn't just objecting to Greystone now, is it? I'm right that it objected to Gilston wind farm in 2011, 2017. Yes.
That's correct.
To Woolmere.
Again, correct.
And the various applications made there. To Cloyk Forests in 2021.
Yes, the objections are to a series of wind farms that would be seen from the high ground in Rayshaw.
To Scordlaw in 2022.
Again, correct, Mr. Trinick.
To Torfican in 2023.
Yes.
And to Leith and Water in 2024.
Yes.
So it's fair to say, and this is not a criticism, Rayshaw is perfectly entitled to take this view. It is pretty thoroughly opposed to any proposed wind farm development in this area.
That would give rise to either scheme-specific or cumulative visual effects on the land comprising the estate. So the answer is yes.
All right. In terms of your field work, you very fairly said you didn't visit Viewpoint 7. What was your field work for the purposes of... I know you know the area very well, I know that. But for the purposes of this project, what field work did you do?
The sequence was an initial assessment of the electronic information on a 24-inch screen, followed by a site visit when I took my laptop out with me. I then did a second site visit, again with my laptop, having reviewed material at home again, and then I did a third site visit with council with the latest cumulative visualisations with us so we could see them in the field. I should explain, and I think Ms Anderson and I are at one with this, I didn't just specifically look at the viewpoints. I went to the viewpoint, looked at the areas around the viewpoint and tried to encapsulate the whole view. For the Heriot Mill viewpoint, in my 2 visits on my own, I had some difficulty identifying the precise location where the photograph was taken from. So the approach there was I walked up and down the track so that I could get a proper understanding, even if I wasn't sure I was at the precise point. So for this specific wind farm, as you know, I've done other work here. For this specific wind farm, there was 3 sets of site visits.
Can I ask Mr. Trinick perhaps to use the...
Thank you. You're a very experienced planner, considerable experience of wind farms, I know that, and you know MPF4 backwards. And we're not here to discuss policy, but we are here to inform the application of policy in terms of landscape and visual effects. And we know what policy 11E2 says about localised effects. I think I'm right that we are actually at 1 on this topic. If we go to paragraph 33 of your inquiry report on page, the last page, you know the consequences of what you say there in terms of MPF4. The further consideration of the visual effects concludes that whilst the effects which have been considered can be seen as localised, in terms of distances involved, they adversely affect a range of sensitivity receptors as a result of generally large-scale change in the view. So we're not in dispute on localised effects in this inquiry.
Not in relation to the one aspect of geographic extent, but I think when it comes to assessing the acceptability of those effects in the planning balance, you have to go beyond just the geography and, as I have said there, consider the sensitivity of the receptors as well as looking at the topography. I think this localised issue is a difficult one for us, public inquiries, the absence of guidance, and also bearing in mind, maybe for the policy session, that the generally acceptable words were written by someone in an office not looking at the scheme or the landscape, and I am distinctly uncomfortable with that. But I think the concept of localised needs to go beyond geography, and I've tried to capture that in the sentence I've put there. But in relation to your specific point, Mr. Trinick, yes, we are agreed that in terms of the geography, they are localised.
That's kind. And
Can I just get the paragraph reference to that?
paragraph 33.
Thank you.
Impressive. I have one more question, and that relates to lighting. We know from your paragraph 13 you don't take a lighting issue in this case, but you do, I think, say in paragraph 26, I think it is, doesn't matter where, that you think that a nighttime site visit would be useful for the reporter.
Yes.
Do you have anywhere in mind which the reporter might visit?
Not immediately. I can give some thought to that. Last week, in the Breakery wind farm inquiry, the same issue came up, and there was considerable dispute around trying to find a wind farm whose lighting would replicate precisely what was proposed at Breakery. It's maybe something we can discuss out with the inquiry, but I think it's important, ma'am, that if you're doing a nighttime visit, then the lighting you're seeing has to be exactly the same as the lighting is proposed here, and that has created a problem. Your colleagues have helpfully undertaken other nighttime site visits for other wind farms, but it's important to make sure it's the right technology. I think we could probably agree aside.
I totally agree. We'll discuss it outside the inquiry. We do have a suggestion, but I won't try and deal with it now. We'll deal with it outside.
Okay.
We'll come back to you.
Thank you both.
Thank you, Mr. Kelly. That's it.
Thank you, Mr. Trinick.
Scottish Borders Council. Mr. Campbell on behalf of Harriet Community Council and others? No. Mr. Findlay, I will come back to you in case you have any re-examination of your witness.
Well, I'm obviously concerned about, to ask Mr. Kelly about the ownership, but no, just one question, Mr. Kelly, and that was on paragraph 33 and your consideration of the visual effects. My understanding, or let me just not lead to this, you've assessed 8 viewpoints 7 viewpoints. And for instance, you haven't assessed Lauder Common nor viewpoint 4.
I haven't assessed Lauder Common or viewpoint 4 for this inquiry. I have been to both viewpoints several times, especially to Lauder Common for other cases.
I'm grateful. That was my only question in re-examination. Thank you.
Thank you very much, Mr. Findlay. I don't have any further questions for Mr. Kelly either. The question of a nighttime site visit, agreed, if possible, and if on par with what is proposed here, then absolutely, but we can discuss that at another time. That then concludes our session on landscape and visual matters. So I will formally close this inquiry session. Looking at the time, it's 10 minutes past 11. So we have been very efficient in terms of the use of our time this morning, for which I would thank you. I don't think we have all our witnesses who intend participating in the policy session. Do you have any indication of when they might be here? I'm just thinking if we can bring forward the policy session even by an hour or half an hour, it would hugely assist in letting everybody prepare and have a break before the community session this evening. Does anybody have any
I am
update?
expecting Dr. Ford any minute, so he should be here fairly shortly.
I think Mr. Campbell, Professor Hughes.
Professor Hughes has told us that it's coming at 1 o'clock, which is what I think we sort of more.
He lives quite close, ma'am. I could phone him if you wish.
I think 1 o'clock. If you could ask him, perhaps, so that he's here and can be prepared for 1 o'clock,
Right.
if that's possible. If not, could you let me know straight away?
So they're going to advance lunch?
Yes, we will have, well, in fact, we will take a break now. Parties can prepare themselves. You can have lunch prior to 1 o'clock. I just think it would assist all of our timings today if we can move the policy session forward by an hour and give everybody a chance to prepare for the community session.
I'm just thinking about, I think Professor Hughes is his role, forgive me if I get it wrong, in the session is to deal with economic and social issues. So we could deal with a lot of other stuff than those issues before 1 and really make up some time.
We absolutely could, but I don't want Professor Hughes to arrive without having the chance to speak to his counsel and instructing party.
My learned friend's quite right. His evidence in this session is confined to socio-economic issues. We could take them discreetly. I think it's really a matter for you. As Mr. Williams says, he doesn't live very far away and he could probably be accelerated by half an hour. For reasons that you know about, which are private, it's difficult for him to leave home just spontaneously.
Absolutely, I appreciate that. Well then, I think we can...
Can I just raise...
Yep.
I understand that the MOD wish to attend and they're based relatively close by. I think on one issue, I was told, but anyway, we can alert them.
If you could, that would be very useful.
We will. And so if there's a start time set, if it's going to be 1 o'clock, we can tell them that it's going to be 1 o'clock.
Well, I think 1 o'clock is entirely possible. We should aim for that. We can accommodate Professor Hughes at a slightly later point in the proceedings, because I am aware that what he is speaking to is quite a discrete part of the policy hearing. So I'm content with that, if everybody else is. 1 o'clock, policy hearing on energy and planning policy. Right, thank you all very much. It remains for me to actually formally close the inquiry session, which I have just done. Thank you all for your participation. It's appreciated. Are here for a hearing session is with the Scottish Borders Council area. The proposed wind farm would comprise of 14 turbines and associated works on a site to the south-southwest of Heriot and west of the A. After I have taken all the evidence that will make my report to Scottish ministers, and that report will cover all topics, not just those discussed at the oral sessions. And I will include a recommendation in that report as to whether or not I believe consent should be granted for the proposal. My report will be Mr. Trinick for the applicant team.
Thank you, ma'am. Yes, my name is Marcus Trinick. I'm a solicitor of King's Counsel, instructed by Amy Howard of Wright Johnson Mackenzie, who sits two to my right. With me in this session and doing much the greater part of the talking will be Alison Sidgwick, who will introduce herself.
Good afternoon. I'm Sidgwick from REAP Consulting.
Good afternoon, my name is Sarah Thompson and I'm a solicitor for Scottish Borders Council, and I'm joined today by Dr Chris Ford, who will be leading principally in relation to the policy session.
Thank you very much, Ms Thompson. And now to Heriot Community Council and others.
Good afternoon, ma'am. I'm John Campbell. I appear with Heriot Community Council, the Fountain Hall Action Group, and on behalf of Mr Walgate, the farmer at Corsop. In relation to the policy matter, ma'am, I am the part author of the statement for Heriot Community Council, so appear here as a layman to assist you in the course of the hearing. I wrote the document with Mr Williams.
And will Mr Williams be appearing?
I hope so. Sorry, I should have said Mr Williams is sitting two to my right, and Professor Gordon Hughes, who's going to speak later about socioeconomics, is sitting immediately to my right.
Mr Campbell. And Mr Finlay, on behalf of Greystone Limited.
Good afternoon, ma'am. My name is James Finlay, King's Counsel. I'm instructed by Susan Leslie from Murray Beath Murray, who sits two to my left, and Ian Kelly, who's going to do most of the talking in this session, sits immediately to my left, and you heard from him this morning.
Right, thank you very much, Mr. And on to Ms Crawford and the Ministry of Defence.
Good afternoon. I appear, my name is Ruth Crawford, King's Counsel for the Ministry of Defence. I'm instructed to my extreme right by Mr Douglas Milne, who's assisted by Mr Douglas Harvey from Morton Fraser McRoberts. To my immediate right is Mr Fraser Littlejohn, Planning Consultant, who will, if it assists the inquiry, speak in relation principally to Policy 11E, Little 4, and the impact or otherwise on the seismic array.
Thank you very much. I note we have members of the public in the gallery today, as well as those watching on the live webcast. The main purpose of these oral sessions, which form part of the entire inquiry, is to make sure that I, as a reporter, understand all of your relative positions on each of the specific topics where I have considered further evidence to be necessary. Where there is a dispute between the parties, I need to be clear on the reasons for that dispute. This is so that those matters can be set out clearly in my report to ministers. This session will be broadcast live on the internet for the public to follow. This session is also recorded and stored as part of the DPA's webcast archive and will be capable of repeated viewing. By participating in these sessions, you are consenting to being filmed and also to the use and storage of these images and sound recordings for webcasting and training purposes and for the purpose of keeping historical records and making those records available to the public. Should you wish to, we have a full privacy notice available for you to view on our DPEA website. We have advised all participants of the general programme. You will note the substantial changes to the anticipated programme, and I would like to thank all of you for facilitating the early beginning of this hearing session, which will assist those of us who are attending the community session later enormously. It is a very long day for all of us, but your participation is appreciated. For those of you who are not familiar with the process, the normal sequence of events during a hearing session is quite straightforward. It is chaired by myself as the reporter. I have had the benefit of all the written submissions, including the hearing statements from all the parties. You have also seen the hearing statements of all other parties, so I hope you are as up to date with those as I am. Hearing sessions are less formal than inquiry sessions. They are effectively discussions involving all the relevant participants, chaired by myself. I have issued an agenda, which you will all have seen. I lead the discussion by starting each item on the agenda with a question to one of the parties. After they have answered that question and I am satisfied with their answer and don't have any further questions, I invite the other parties to comment. This usually leads to a further exchange of views. When I am satisfied that I have sufficient information on that topic, we will move on. It's worth bearing in mind that the purpose of this hearing session is not to persuade me of your point of view, but to actually help me understand your respective position and to understand where there are differences and why there are differences in your positions. As I have said, all of the written representations and consultation responses which have been received to date in relation to this case will be taken into account in preparing my report. All of those can be viewed on the DPA webpage under reference WIN-140-9. For the benefit of those who weren't here yesterday, I have already carried out of the site and the locality. I carried those out in late 2024 and also in the past few weeks. I've viewed the site from the viewpoints set out in the environmental reports, and I have also viewed it from the routes surrounding the site to the east and to the west. I've walked part of the core paths referred to, not all of them, and I have looked at the relevant viewpoints and the general vicinity of the site. During this process, I will determine whether or not I need to make further site visits and whether or not those site visits will be accompanied. An accompanied site inspection means that all parties, or as far as possible all parties, will be in attendance. It's not an opportunity for further evidence to be discussed, but it will ensure that I have seen all the relevant physical elements of the proposed development. Before I move on to some brief housekeeping matters and the agenda itself, I would like to remind you all of the importance of being courteous to each other throughout this hearing session. You may hear things you don't agree with. and you may hear positions that you don't agree with, but please try to be both polite and respectful in your answers and your discussion. Please give people the time and opportunity they need to express their views and to give their evidence. I mentioned yesterday that it is useful for summaries of case to be submitted by the parties, mainly because multiple issues and numerous documents are covered and referred to. If you require, a template can be forwarded from DPA to yourselves to complete. It means then that your summary, rather than mine, is included in my report, which is more efficient for me and also possibly fairer. In terms of housekeeping, there are a number of issues. For those of you who haven't been here yesterday and this morning, you will note the rather dramatic looking police tape on the floor. That is because we have limited power sockets that are functioning in this room. So please be careful of cables when you're walking around the room. Please be aware that there are cables across the floor. Is everybody warm enough? There is an open window at the end. It is a very airless and warm room. If it does get too warm, we'll attempt to open some other windows. There is no fire alarm scheduled for today. If a fire alarm goes off, it will be a real fire alarm. The escape routes, the primary escape route is back to the main reception, down the main stairs and out to the further fire escape route of this room and then immediate left. Some other matters are when you are not speaking, because this is being webcast, the webcast cameras follow the microphones. When you are not speaking, if you can switch your microphone off, and when you are speaking, if you can try to remember to switch it on, then the cameras will automatically go to you. It goes without saying that mobile phones should be either off or switched to silent. Because we are starting an hour earlier, I anticipate that we will finish sometime between 3:30 and 4, maybe even earlier. If everybody is content, are there any questions on the procedures I have just outlined? Nope. Well, we will move to the hearing agenda. I have already made the introductions. I would say that, and I would thank you all in advance of this afternoon's session for the comprehensive hearing statements that I received from all of the parties. It does mean that my actual questions on planning and energy policy are, in relative terms, limited and maybe more strategic, and I don't mean that in the planning sense, than might normally be expected. But that is because your hearing statements were so comprehensive, for which I thank you. Could we begin at item 2, statement of agreed matters? This is a question for the applicant, and it is, can you confirm the latest version of the core document list, the latest version of the statement of agreed matters and the core document list reference?
The statement of agreed matters, I believe, is the one that was submitted on the 21st of January 2025, and that is CD 16.6. And that document has a number of track changes, which I can run through if it's of assistance, but if it's self-explanatory, then I'm happy to leave it.
No. I'm quite happy that it is self-explanatory. Thank you. Is everybody else content that they have access to CD 16.6, which is the most up-to-date statement of agreed matters? Yep.
And the core documents list. Just double checking the reference to make sure I've got the most up-to-date one. It was submitted yesterday, and I'm not sure it has its own number.
From my look at lunchtime, I don't think it does, but I think, and subject to the Ministry of Defence confirming that they have received it, the latest version of the core document list is dated yesterday, which would be the 28th of January. It would have come by email from the applicant around lunchtime yesterday.
Yes, I can confirm we've received that. Thank you.
Lovely, thank you very much. And again, to the applicant, are there any elements of the statement of agreed matters, latest version, that are pertinent to this session that you feel we might need to look at this point?
Yes. Data in respect of MPF 4 and Policy 11.
When we get to the relevant part of the agenda, we can come back to that. Okay. Moving to agenda item 3, the National Planning Policy Context for Onshore Wind. This discussion, as I set out on the agenda, will consider, but won't be limited to, the overarching provisions and stance on the various energy policy statements, strategies and plans, to MPF 4, to white papers and to other policy contexts, both in Scotland and across the UK. I have indicated that the MPF 4 policies we will discuss specifically will be Policy 11, Policy 1, Policy 3 and Policy 4, and we will discuss them in that order. At present, I don't envisage us straying beyond those MPF 4 policies in terms of our discussion today. I wanted to begin with a reasonably wide question to the parties on the policy ambition set out in the suite of Scottish Government policy relating to energy and net zero. Is it fair to say that the parties agree that there is a clear indication and a policy ambition for an increased deployment of onshore wind energy, in particular in the period to 2030? And could we begin with the applicant for that question?
I would agree that the suite of documents that we've got is pushing towards the increased onshore wind between now and 2030 in particular. Within that, the onshore wind policy statement, which is CD 812, I think is one of the keys in my mind. It's referenced in most decision notices from onshore farms from Scottish ministers, if not all of them. And it's a very clear document in its setting of the ambition. Minimum, and highlight the word minimum, installed capacity of 20 gigawatts. This isn't a cap, it's an ambition, it's a target, so we can exceed it, and it's clear it's ambitious. And I don't know if you want me to go on, but I can talk about the potential to meet that target. And in my hearing statement, I've covered that off, but I'd particularly draw your attention to the most recent BVG report update, which is called document 8.49, and the conclusions in that document, which I think are particularly relevant. And those conclusions focus on the fact that we are seeing project delays, and that is adding to the uncertainty of meeting the target and could lead to a reduction of 1.1 gigawatts of operational capacity between now and 2030. If we're to hit the 2030 targets, we do have to rely on new projects which are not yet in the public domain. And it takes some time to bring projects forward, and we've now got 5 years between now and 2030, 6 years. But also the number of consents would need to double in the next 3 to 5, over the next 3 to 5 years to hit those targets. So to my mind, the BVG report is a stark reminder of the challenge that faces us from that point of view. And I suppose the another facet of it is having read some of the evidence of other parties, is the role in which repowering may play in hitting that target. I don't disagree that there are a number of lifetime, but in my experience, we're not seeing large numbers of projects come forward for repowering. I think the only one that has been is Hagshaw, and that is being developed at the moment. Ben Akatil is behind that and is going to PLI, I understand, later this year. Wind Standard 1 is the subject of an application which was submitted 2 years ago and is not yet determined. Ben Glass and Hare Hill are both, but I'm not aware of other projects in the public domain coming forward. And if we think Windy Standard is taking 2 years to determine, it's not a swift process to get repowering through the system. And I've been involved in 3 of those projects. I'm still actively involved in one of them. It's a big ask. It's not an easy EIA. It's not an easy process to go through repowering. It takes time to be done properly. I think my view in this is reinforced by the comments of the reporter in the case of the recent Woolmuir decision, which is CD reference 10.43 at paragraph 94. And the conclusions of the onshore wind policy statement are very clear. It's mission critical to meet those targets. And so, from my point of view, the onshore wind policy statement is a key document. And is very clear in its outline. I don't know if you want me to talk about some of the other documents. The Energy Strategy and Just Transition Plan is a draft document at the moment, and it should be treated as such. And it's a document that looks at energy strategy across the piece. So it has a relevance, of course it does. It's part of the framework, but it doesn't have the same direct link to onshore wind as the onshore wind policy statement. Thinking about some of the English documents or Westminster documents, they are again part of the framework. They're something we should have regard to, but they are, in my mind, of less weight in the decision-making process than the onshore wind policy statement. And I know you've got MPF4 in your list of documents to be considered in the agenda item, but I'm assuming we'll come on to that in its own right.
Yes, I have some specific questions on MPF4, so probably best to not address MPF4 in response to this question.
Yeah, I think that's all I'd say on that sort of suite of documents at the moment then.
Thank you very much, Ms Sidgwick. I'm going to move to Scottish Borders Council, and if you could answer the same question, Dr. Ford.
Good afternoon, Ma'am. Thank you. Yes, I agree with it.
Oh, sorry. There we go.
Good afternoon, Ma'am. I agree with your initial statement of, is it increasing? Is the ambition to increase? Yes, it is. It's a simple answer to that question. Obviously, we're talking about the 20 gigawatt ambition. It's quite right to describe it as an ambition rather than a target. My understanding is that at the time that the ambition was issued, and obviously it came through into policy through the OWPS, it was set as a number target. But my understanding is that actually there have been any that into whether it's required, what it will deliver, and its peak value. So in a sense, there's a bit of a gap in the policy situation there. Obviously, it came out of the coalition agreement, and my understanding is the figure was really given to the Scottish Government by the industry as essentially the capacity that they could deliver by 2030. I have set out in my own submission, Ma'am, in my own statement, 4.20, the position in terms of what's been delivered so far. And essentially the position is that we are in operation about 9.3 gigawatts. There's approximately another 1.5 gigawatts under construction, and really up to another 7, which is and awaiting construction. Ms. Sedgwick also mentioned repowering. I think it's fair to include that. And we should be thinking about the value that repowering can deliver. The other thing to say about repowering, and Ms. Sedgwick's quite right to point out that some of these projects are not coming forward for repowering, but are extended situations, and therefore we're not necessarily losing the capacity that they already provide. That life extension is really another alternative to maintaining the current capacity that exists. We're not that might be arrived at through repowering.
Sorry, apologies. Dr. Ford, when you say extended, do you mean in terms of the planning consents, which previously had normally been between 25 to 30 years, extended to 35?
Yes.
Right.
Life extension. Yes, that's right. So an increase in time. And the other thing to say is that there's also a reasonable prospect of increased capacity being done through extensions to existing wind farms rather than existing new virgin sites, such as this proposal. There's a benefit in extensions to existing wind farms in that, in a sense, there is an established use there. There is a accepted and residual environmental effects of them, for example, and therefore extending those wind farms is likely to have less significant environmental effects than providing for absolutely brand new sites such as this proposal. I suspect one of the issues of difference between us, Ma'am, is really to do with this issue around how much of the consented capacity is likely to be built. I don't think that will be a surprise to you, Ma'am. As I say, the 20 gigawatt ambition was really effectively a figure that I believe came from the industry in terms of what it could deliver. And there are obviously, I suspect we'll discuss this elsewhere, issues around the ability to deliver capacity and consent. But there's two sides to this. One is that essentially consents don't necessarily deliver the capacity, is the simple, obvious explanation. And in a sense, giving more consents don't necessarily deliver more capacity. The problem essentially is the fact that the viability of many of these proposals is in question. From my own research, my understanding is that that viability is getting more challenging as time goes on, particularly for onshore wind energy, and particularly in Scotland, incidentally, because of the additional transmission charges that occur in Scotland that won't, for example, apply in southern England. And therefore, I do think there are some issues about the doubts about whether or not we will get to the target. The second point is that really this is just an issue about what the supply chain can deliver and capacity in that side of things rather than trying to meet a particular capacity. And in a sense, we should recognise that. We should recognise the fact that many proposals don't get to viability. And in this case, we'll say that I've heard those kind of statements in inquiries, only to see that proposals have been taking forward a reasonable period afterwards. I'm talking 4 or 5 years afterwards. So I think the point I'm trying to make here is that essentially just consenting wind farms isn't going to fix the problem. And really, you know, I always understood it was an ambition. It's fair to describe it. It's a wish. And it's therefore not a fixed or final target. And we should treat it as such. I appreciate it sits in policy documents, Ma'am, and therefore we will no doubt consider it.
I think, would it be fair to say, Dr. Ford, that it's a clearly set out
yes.
in adopted Scottish Government policy.
Agreed. And Ms Sedgwick also mentioned English documents. Will we come on to that a bit later on, in which case I'll just leave that till later.
I'm not intending to discuss them in any specific, so if it's relevant to your answer to this question, please include reference to them.
Yeah. Well, I think we should include the English documents, and I do think actually they should be given quite considerable weight. For the obvious reason that this is a consent under the Electricity Act, which is UK legislation. Energy and energy policy is a reserved matter for the UK government. And therefore, the developments that are taking place there need to be fully recognised. One of the other things that we should also recognise, particularly in terms of the Scottish Government's commitment, is its position in terms of the Strategic Spatial Energy Plan, where the Scottish Government is a party to that document. And that is a proposal to take forward a planning arrangement for the whole of the GB system, and it's perhaps just worth giving some context to that before I get into too much detail on it. Historically, we have had what is known as, what I should refer to as a developer-led energy system. It is developers who have chosen sites, decided to bring them forward, sought consent for them, and sought grid connections for them. That has ultimately led to a dysfunctional energy market over the last few years, and that has been recognised through the work that's gone into the REMA programme, the Review of Electricity Market Arrangements. And so for the last 4 or 5 years or so, the UK government has been simply seeking to try and address the dysfunctionality of the energy market across the whole of the GB. The spatial picture essentially is that we have consented a lot of wind farms, a lot of energy developments in Scotland, which is far beyond the domestic need. The numbers simply are that currently operating we have 12.3 gigawatts of wind energy, that's onshore and offshore, but Scotland only consumes 3.5 gigawatts of energy on average across the year. It rises in the winter time, it falls in the summer, but the average across the year is 3.5 gigawatts. That is a considerable excess of power beyond indigenous need. And the policy, Scottish policy, does recognise that the surplus can be exported out of Scotland, but that is creating problems for the GB energy system, and it's part of the issue that the UK government has been seeking to address for the last 4 or 5 years. In about 2021, the UK government asked the regulator and the electricity systems operator to try and think about the dysfunctional arrangements within the electricity market. And both of those organisations spent about a year, 15 months, looking at this matter in detail. They came to the conclusion that the biggest problem overall in terms of the spatial distribution in particular for the UK market is that the generation that's being built in Scotland is not adequately reflecting the locational costs to the energy system of it being located in Scotland. In other words, increasing cost to consumers by locating generation a substantial distance away from where it's going to be used. In simple terms, it's about 500 kilometres from the middle of Scotland down to London, which is an area where there is a requirement for energy to be provided. As a result of that, the UK government has started to look at different arrangements to try and solve this problem. And they're really running 2 parallel tracks of policy development. One is the review of electricity market arrangements, and one of the issues up for discussion and up for consideration in that is the proposal to move away from a unified wholesale electricity price for the whole of GB, for the whole of Great Britain, to individual electricity prices for different regions. Technically it's known as locational marginal pricing, where the markets will be broken down into something like 6 or up to 12 different regions across the whole of GB.
Dr. Ford, we're probably getting into too much detail on those specific things, but I will slightly reframe my question in terms of those particular UK-wide ambitions in terms of a spatial energy market.
Yep.
In the context of the Scottish Government aim of a particular target to 2030, realistically, will they make any difference to that delivery in Scotland?
The answer is
before
yes.
2030.
Yes,
given we're at 2025
the answer is yes, they will, ma'am. In the event that locational marginal pricing is introduced, and I understand this, the UK government is likely to decide that this summertime, what it would do is to change the fundamental economics of the Scottish electricity market in 2 ways. One is the price would be based on the local requirement in Scotland. As I said, there's a substantial excess of generation in Scotland over and above requirement. And as a result of that, the wholesale price in Scotland is likely to be substantially reduced. I've heard figures of 15% estimated going forward. 15% of the current wholesale price.
So the value would be 15% of what it is now, or would be reduced by 15%?
Would be reduced to 15% of what it is now.
Okay.
A substantial cut. The upside for Scotland in that situation is that domestic electricity prices would fall commensurately. So there are some positives to this in terms of Scottish position. The second issue, and perhaps as part of these arrangements, there is also on the table, and it's built into for REMA, is the removal of constraint payments. Don't want to get into too much detail, ma'am, but essentially we have the excess of energy in Scotland produces a situation where power have to be turned off because there is no other way to get energy. At the moment, those generators are compensated for the energy that they would have produced. That cost is picked up by UK consumers, GB consumers, and on the other side, there's an additional cost that energy has to be replaced elsewhere in the grid, essentially by providing gas-fired power stations in England, basically. So at the moment, that cost is running about £2.5 billion per year. So one of the key elements of locational marginal pricing, is that subsidy that is removed. Okay. Now I could go into more detail about the other options that are on the REMA options, but essentially that's the most likely option to be taken forward. The other option is to find other mechanisms within the market arrangements to try and address these locational signals to generators. One of which is to substantially increase transmission charging, and I'm talking about orders of magnitude here. But as the documents say, the most likely candidate is locational margin pricing. The other track that the UK government is pursuing is to address this developer-led market, which is, as I said, led to a highly dysfunctional market, is to change the way in which grid connections are made available. So at the moment, every generator is entitled to a grid connection. They will pay the local connection charge for the connection itself, and they will be given a date when they expect that can be given. Some of those dates are now running into the 2040s because of the amount of transmission infrastructure that needs to be built to address that. And one of the key elements that's being talked about and is really a fundamental change in the way the energy system, and it's really stated in the Strategic Spatial Energy Plan for Energy, is that rather than developers deciding where generation goes in the future, the system operator will decide under the guidance of government. And when you start to think, in other words, we are moving towards, we are moving towards a planned energy system where, under government guidance, NESO will direct where generation is going to be required in future. Under those arrangements, it's quite likely that Scotland doesn't really need any more generation requirements. because we have such an excess at the moment. So those are the two broad tracks that are taking place, ma'am. Thank you. And they will have an impact in Scotland.
Thank you very much, Dr. Ford. Moving to Mr. Campbell and Harriet Community Council and others. Mr. Campbell, can I take you to the question, are you in agreement that it's a clear policy ambition for increased deployment of onshore wind energy?
Thank you, ma'am. Good afternoon. Your question was directed to the onshore wind policy statement, which I respectfully remind you now is dated 2022. So it is showing its age. In my submission, the 2022 statement is the wrong place for you to start. You should start by reminding yourself that what you're being asked to do in this case is make a locationally appropriate decision for the proposal that's in front of you. And the place to start when that comes into your mind is with the Electricity Act of 1989, which sets vague but clear criteria for the location of generating stations in excess of 50 megawatts. The second thing to say is that in Ms. Sidgwick's careful summary of the importance of the onshore wind policy statement, she did not draw your attention to those parts of the onshore wind policy statement which urge decision makers to exercise caution, or in any event appropriate decision making, that's to say choosing locations which are appropriate for all sorts of reasons. I don't wish to revert to today's discussion earlier, or indeed yesterday's, but what you might care to note is that the OWPS, enshrining as it does ambitions for an increase in renewable energy generation, nevertheless is caveated in a careful way to encourage the decision maker to make appropriate decisions, not just any decisions. Now, those are my simple points in relation to your particular question.
Right. Thank you, Mr. Campbell. Moving to Mr. Findlay and Mr. Kelly.
Ma'am, thank you. Good afternoon. You have my evidence in the hearing statement, so there's only a couple of small points I will add. My understanding for Greystone now is that the earliest grid connection is 2031, and therefore the 2030 target is not relevant for Greystone now in that respect. And secondly, I see that you're presented with some 49 climate change and energy policy documents to read. Best of luck. But as Mr. Campbell said, you're being asked to make a recommendation on a locational decision. And as far as I can see, it is only NPF 4 that gives you specific guidance and criteria for a locational decision around the right development in the right location. Thank you, ma'am.
Thank you, Mr. Kelly. The same question to the Ministry of Defence, and then I will have some follow-up questions for various parties. Thank you.
Thank you, ma'am. If I may, I'll speak to the general question which you asked, and if I may remind the inquiry of the MOD's position at 4.48 of its statement for this hearing session, to the effect that the MOD supports the renewable energy targets and respects the Minister's policy in that regard. However, the MOD's position is of course caveated by its international obligations to protect the array at Eskdale Muir. So it follows from that the MOD takes no issue with the fact that the targets are as stated in the various policy documents. It would not be appropriate for the MOD to enter into a debate about the source of those targets, whether or not they were industry-led, or the process of consultation which may or may not underpin those targets. Equally, it would not be appropriate for the MOD to comment on whether consents in fact deliver capacity, nor the interesting discussion about consents and capacity versus the question of need in Scotland, nor whether the energy market has, at least in the past, been developer-led, and nor to engage in the interesting discussion about whether or not the energy market has been dysfunctional and is now moving towards functionality. I say that, of course, recognising that I'm here representing the MOD, a United Kingdom department, but self-evidently I don't represent the Department of Energy and Net Zero, and I for the MOD to comment further on those matters. And as I say, ma'am, that is not because I don't wish to assist. It's simply MOD does not have the policy remit for those areas.
If I could take the parties back a step in making a locational decision on a site-specific proposed development such as a wind farm, and in particular a wind farm at Greystone now, is it not the case that national policy has to be taken into account? It's simply not a simple locational decision. Have to be given appropriate weight by the decision maker. If that could go back in the first instance to Mr. Campbell.
Sorry. I entirely agree with you. Of course it's relevant to the locationally appropriate decision.
Thank you. To push through on. Phone is on. Do you?
I've turned it off.
Still on. That's it. Okay. Sorry, I thought you might wish to ask a question. If so, then I will move on to Mr. Trinick.
May I just come back briefly on one or two comments we made? It'll be extremely brief.
Yes.
Thank you. Mr. Ford, I admire his siren song, but you are required to apply policy as is, not policy as it may be in the future. That's an obvious statement. But in rehearsing REMA and the Strategic Spatial Energy Plan, he is looking to the future, not to current policy, which you must apply. So far as Mr. Campbell's point is concerned, the vague but clear criteria, if that means Schedule 9 of the Electricity Act, which I imagine he is referring to, that of course is a have regard to provision, not a substantive test, as has been found in decisions which Mr. Drick will take you to if required. The caveated advice point from the AWPS, I entirely agree with him. Nothing to add there. And that is all I have to say. Thank you very much.
Thank you, Mr. Trinick. Dr. Ford?
Just to come back on the future policy idea, the Strategic Spatial Energy Plan is not future policy. It is existing. It is a commitment, a planned operational arrangements rather than using the developer-led system that we've had in the past. There's a very fundamental change in the way that the energy system works. I appreciate many generators are still catching up with it, if you like, but actually if you look across the proposals coming forward in Scotland, it's very clear that the experienced generators understand the picture coming forward and have adapted to it, but that's existing position. In terms of REMA, technically right, REMA is still being evaluated and brought forward. However, the May document the REMA document issued in May 24 is a second consultation indicating decisions made by UK government. They have committed to the position that they will either introduce marginal pricing or they will find other arrangements to address the locational problem for the GB energy system. That is a committed position, what they're moving towards now is, if you like, the choice between those two and how to and implementation. Thank you.
Thank you. Dr. Ford, can I take you back to your comment about existing operators in Scotland adapting their market behaviour? I think I'm paraphrasing you. Can you outline in what way those behaviours have been adapted?
Some of the more senior, more experienced long-term developers have started to move away from the Scottish onshore wind industry. They are focusing offshore, and they are focusing, I suspect some of them are going to focus onshore in England and Wales. And therefore, we're seeing a change, if you like, in the types of developers who are starting, who are using, pushing forward with rather, onshore wind energy in Scotland, so that they are generally the less experienced developers. I suspect it's because they have less understanding of the regulatory changes that are in tow.
But we don't know that. These are market decisions that operators make on their own terms that we really could guess at but don't actually know. Okay, but noted, Dr. Ford. Okay, I'm content that I have heard enough on that particular question. I'm going to move to quite a specific question, which is, can the parties give me their view on what the potential implications of the suggested suspensive condition relating to Eskdale-Muir seismic array and a potential delay in implementation and discharge of that condition that might cause to the contribution the proposed wind farm may make to the 2030 target? Yes, happily. So, my question effectively is, the applicant has suggested a suspensive condition in relation to the protection of the Eskdale-Muir seismic array, and that suspensive condition is capable of being discharged following the resolution of a number of work streams and potential changes to the current consultation zones and headroom at the array itself. What my question relates to is what that suspensive condition and its discharge would have on the contribution this proposed wind farm could make to the 2030 target, bearing in mind we're in 2025 at this point in time.
Ma'am, it's entirely for you, but we are rather straying in tomorrow's conditions agenda. I'd happily answer it, but we will be talking about this in detail tomorrow.
We will be talking about it in detail, but it's really on the 2030 target. And will that condition have an impact on the ability of Greystone now to contribute to that target? A simple yes or no will suffice.
Ma'am, the grid connection date for this project is 2030-31. That probably has more impact than Eskdale-Muir on our evidence. In the contribution of this project to 2030 targets, but in terms of the implication of the suspensive condition, I really would rather deal with that tomorrow in the condition session in detail, so we don't go over it twice.
No, absolutely. Dr. Ford?
Again, Mum, I was more prepared for this to be tomorrow, but let me just try and pick up one point. It is apparent to me that we have an existing policy in terms of the Eskdale-Muir array, and that is essentially the 2014 algorithm. There is potential policy change and implementation change with the discussions that are taking place. Whilst in general terms Mr Trinnick is right that the grid connection, in a sense, takes this proposal out of those discussions, because one is hoping that those discussions will be concluded by 2029, 2030. But I think there's another point here, which is essentially that, as I understand the changes that are being considered, they include two, as well as the change in the headroom, they include two other potential changes. One is to push the exclusion zone out to 15 kilometres, and the second one to give some sense of spatial dimension within the 15 to 50 kilometre distance because of the differentiation of the impacts of turbines on the array at different distances. So it does seem to me there's a potential situation here that essentially, not necessarily for this proposal, but if this approach is taken with other wind farm proposals coming forward within the 50 kilometre zone, we may be in a position in a few years' time where the suspensive condition becomes quite chaotic, if you like, because imagine a situation where 4 or 5 wind farm proposals have gone forward with this suspensive condition, and at that time, when the Scottish Government wants to try and implement a spatial dimension within the 15 to 50 kilometre zone, to my mind it's going to create a lot of confusion, and I think that's a difficulty that in some way needs to be addressed. Thank you, Mark.
Thank you, Dr. Ford. Mr. Campbell?
No, I don't think I've got anything to contribute to this. I couldn't contribute tomorrow.
Okay. Absolutely.
In my mind, this is about the effectiveness of the suspensive condition. It may or may not have something to be said.
To my mind, it's more to the effect of the condition rather than the effectiveness of a specific condition.
As a community council representative, I'm not going to be drawn into speculating on that area. I'd rather listen to what my learned friend Ms Crawford has to say, if you don't mind.
Thank you, Mr. Campbell. Mr. Findlay?
Just to say that it's another contributory factor, as well as the grid connection date, as to why it's going to, this project is unlikely to contribute to the 2030 target.
Thank you. Ms Crawford for the Ministry of Defence.
Well, as a matter of logic, it would seem that if consent is granted subject to a suspensive condition, which is not discharged for many years, for whatever reason, and the condition session tomorrow will hear submissions relative to what is required or what may be required before one could ever be in a position to discharge such a condition. But with all those hypotheses, as a matter of logic, it would seem that the ability of this development to contribute to the target for 2030 may be somewhat remote. But I'm very conscious of the fact I'm very much speaking in the abstract there, just looking at the matter as a principle of logic. And of course, as parties have already alluded to, the MOD's position is, and this will be developed tomorrow, is that it would be inappropriate and contrary to the guidance in the circular for any suspensive condition to be granted.
Thank you, Ms Crawford. Mr Trinnick.
Just briefly, again, I hear what Mr Ford says, but I also see that Scottish Borders Council, in the conditions, declare themselves neutral on this issue. So I'm not sure why we're having this contribution from Scottish Borders Council in that context. They've declared themselves neutral.
It's because the question was about the effectiveness of whether the suspensive condition is going to affect the target, and that was the question.
Noted. I don't have any further questions on that matter, and I don't actually have any further questions on energy policy in general or specifically. As I said, all of your written hearing statements were very comprehensive. I have taken them fully into account. Unless any party at this stage wishes to make a question or put a question through me to anybody else or comment on anything you have heard or anything I haven't identified in the hearing statements as submitted, I am going to move on to National Planning Framework 4. Is everybody content that I do that? Good. So moving on in the agenda, I have some general questions on MPF 4. I note we've been sitting for an hour. I'm going to suggest we do the general questions that I have about MPF 4. They may generate longer answers. Hard to know. I suspect they might. But we will then take a break after my general questions on MPF 4 before we move on to policy-specific MPF 4 questions. That should lead to a break sometime about 2:30. We'll break for 15 minutes and then reconvene. So, moving to National Planning Framework 4, which in the core document list is 6.3. And my first general question is to the applicant, and it is, do you agree that MPF 4 needs to be read and applied as a whole, with factors for and against a specific development to be weighed against one another?
I do agree with that, Ma'am. Apologies. I do agree with that, Ma'am. I think Policy 11 is obviously an important policy. It's the development-specific policy, and I think the other policies that you have identified for discussion are also important policies. There are some policies that, when you read it, are not relevant to the proposed development, but I think you need to read the document as a whole and understand it as a piece.
Right. Thank you. Apologies. I'm guilty myself of not turning my microphone off when not speaking, so I've reminded myself to do so. The same to Dr. Ford.
One word answer, ma'am, yes.
And Mr. Campbell?
Yes, I agree with Dr. Ford.
And Mr. Finlay?
Nothing to add.
And Ms. Crawford?
Again, nothing to add.
Well, that was very swift. Thank you very much for your succinct answers, always appreciated. In relation to National Spatial Strategy and MPF 4, how should I interpret the reference to the right development in the right place in the context of net zero commitments? It's a fairly wide-ranging question, but sometimes goes to the crux of what we as decision makers need to decide. And to Ms. Sidgwick in the first instance.
It's a question that has vexed planners for as long as I can remember, and that's pushing 25 plus years. There isn't an easy answer to that question, I don't think. It is a question which a number of reporters have dealt with in some recent decisions, and then they have looked at it and they've thought about it. And I would refer you, ma'am, to Glen Dye, which is CD 1023, and paragraph 9.140 and 9.103. Sorry, I'll start again. Sorry, paragraph 9.104 and paragraph 9.103. And that points to it being for policy to define the right development, the right places and things. And I think if we look at the energy policy, I'll just get the right reference so I don't get it wrong, but Part B, Part A is very clear that development proposals for all forms of renewable, low carbon and zero emissions technologies will be supported. And then Part B tells us that development proposals for wind farms in particular, they are singled out, in national parks and national scenic areas will not be supported. So I believe that there is support in principle for wind farm developments as long as they are not within NSAs or national parks, subject to consideration against a large number of matters, including all the issues that are identified in Part E of Policy 11.
Thank you. The same question to Dr. Ford. If I could just get you to switch your microphone off. Thank you.
A bit of agreement here, Ma'am, largely agreeing with Ms Sedgwick. I think the right place, the one thing I would emphasise here, adding to what's been said, is that the right place means taking account of the local environmental effects that might arise from that development in this particular place. So that's obviously going into landscape issues and other issues which you've already covered, obviously.
Thank you, Dr. Ford. Mr. Campbell.
Yes, I respectfully agree with Dr. Ford. In approaching this matter, I would urge you to read Policy 11 very carefully. It isn't prescriptive or binary. It isn't one way or the other. It isn't localised or non-localised. What Policy 11E2 says, that project design and mitigation will demonstrate how the following impacts are addressed. So it's an injunction upon the developer to show, let's say on a balance of probabilities, how these impacts are addressed. The remaining framework for the decision is yours, because you have to decide whether the addressing of these problems produces a satisfactory result or not. With respect to Ms Sidgwick, she's given us a number of examples of reporters in a table, I'm sorry I forgot the number, a table where it's shown certain decisions and how reporters, and taking very small context of reports, one could take issue with those, but this is not the time, perhaps in the closing submission. But don't understand this part of the policy, please, as simply offering you a binary choice. It offers you a framework, and the clue, if you need one, is in the title. It's a national planning framework.
Thank you, Mr. Campbell. Mr. Finlay? Or Mr. Kelly?
I'll do it. Ma'am, notwithstanding the general policy support for renewable energy, you are still looking at locational decisions, and your colleagues, again on a locational basis, are still prepared to recommend refusal of schemes, as happened at Strathoikel, and ministers, again notwithstanding the general policy support, are prepared to recommend or to refuse schemes, as they did at Contradwell. So, notwithstanding that general policy support, I still think it comes down to considering the development and the location of the development.
Thank you, Mr. Kelly. And Ms. Crawford?
Thank you, ma'am. Again, I would direct you to the MOD's planning its statement for this session. Of course, recognising that Policy 11 provides support for all forms of renewable development, but that is subject to the requirement this time in 11E Roman 4 that project design and mitigation will demonstrate how the impact on seismological recording is addressed, and of course that will be the subject of tomorrow's hearing.
Yes.
But in the MOD's submission, obviously, their position is that this is clearly a very important spatial element which you will require to consider and attach, we would submit, significant weight to.
Right. Thank you, Ms. Crawford. Unless there are any comments or questions through me, I will move to my next general question on MPF4, which relates to national development status and wind farms and renewable energy. Do parties agree that MPF4, through national development status, provides support in principle for such proposals? And again, starting with Ms.
I agree with that, ma'am.
Yes, ma'am, I agree as well. Obviously, it doesn't mean that any decision on any individual proposal is foregone.
Ma'am, I'm not sure that I do completely agree. The use of the language doesn't suggest a blanket confirmation with just because something is a national policy, it doesn't bestow upon it some sort of inviolate status. What it says is, or what it tells you is, this is a matter that the government regards as important, over and above the routine applications for development consent. I don't see it as going further than that.
Mr. Finlay?
In my interpretation, the text gives national development status to this type of development, of this category of development. It doesn't give the proposal any form of outline consent or prior approval. The text is supporting a type of development as a national development. Thank you.
And Ms. Crawford?
Thank you. Without wishing to repeat previous answers I've given to the questions asked of parties, I simply direct you, ma'am, to the previous answers I've already provided under reference to the hearing statement and, of course, the MOD's respect for policy decisions made by the Scottish Government.
Thank you. Those are the end of my general questions on MPF 4. I think we could take a break now, reconvene at 2:30, and we will move on to my questions in relation to Policy 11 specifically. So if everybody could be back promptly at 2:30. For those who weren't here yesterday or earlier this morning, there are coffee facilities in the lobby. And as indicated before the break, we will move to my policy-specific questions on NPF 4, beginning with Policy 11. Policy 11 is in Part 2 of NPF 4 and is on physical page 53, electronic page 54. And for those of you following the core document numbering system, it's CD 6.3. So if I take you to the green heading, Policy 11, Part A sets out that development proposals for all forms of Part B. Part C sets out that they maximise, including local and community socio-economic chain opportunities. My first question is, has it been demonstrated that this proposal does that? And to Ms. Sidgwick, please.
Thank you. I think that it has been, and my reason for saying that is the process that has been undertaken is very similar, if not the same, as the process has been taken in other applications where information has been provided in the context of the Environmental Impact Assessment Report. And you would find that in CD 1.2 at chapter 12, which is where the EIA report sets out the economic impacts of the development. That includes a variety of information which I won't repeat here. And the provision of that information, its reiteration in documents such as planning statements, has been accepted by reporters and the Scottish ministers as providing evidence that it will be maximised, or that they are satisfied that that policy has been satisfied. And I would refer you to examples in Holland May, which is CD 10.20, and Tom Clach, which is CD 10.35. The other thing to note is that it may be covered tomorrow. There's a supply chain protocol, and I believe that is condition, I want to say 25. It is. 25.
And that's an agreed condition with Scottish Borders Council.
Yes.
Are you... Nothing further. Thank you. And on behalf of Scottish Borders Council, Dr. Ford, the same question. Do you consider it has been demonstrated that net economic the proposal has maximised net economic impact?
The answer, ma'am, is I'm not sure. And that's not because of just the evidence that's been presented by the applicant, but also because it's actually quite a technically difficult question to answer. I appreciate that the applicant is, if you like, put in the, I don't want to be derogatory, but the general standard information that comes in on these things. But I'm with all of these things not necessarily convinced that it is maximised, because that's the operative word here, the net economic impact. Whilst the clause itself also refers to local impacts, local economic benefits and stuff like that, but my understanding of the main reason for this clause was the really sad record that the industry has had with supply chain over the last few years or so. There's a UK parliamentary Scottish committee, I think it was, investigation into it shortly before MPF was finalised, and it certainly showed a lot of poor record. We haven't fundamentally moved forward from that position, I'm afraid, and therefore, you know, we're not seeing a lot of movement by developers to really push this forward to the point where we're getting maximum economic value out of generation development. So I'm afraid it's a kind of sorry story, really. So in my sense, my understanding is that whilst I accept that the applicant has done what is normally done in these circumstances, I don't think that means that the situation has, that the evidence has maximised the potential net economic impact. Thank you, ma'am.
Thank you, Dr. Ford. Do you consider that Part C of Policy 11 MPF4 is satisfied by the evidence submitted by the applicant?
Personally, no, ma'am.
Okay.
So can I just get clarification there? When you say personally, do you mean on behalf of Scottish Borders Council?
My position is that I have not discussed this with the council. It's not been prior approved. It's my assessment, and I'm here to represent the council, sir.
Okay, moving to Mr. Campbell on behalf of Harriet Community Council and others, the same question.
Thank you, ma'am. Like Dr. Ford, I'm unsure. Looking at the text of the policy, it contains words which require definition, and to my mind, on behalf of my clients, we're not satisfied that economic benefits are maximised, although I accept that's a difficult thing to define with precision. But I draw your attention to Professor Hughes' statement in this part of the inquiry, paragraph 6. I'd just like to ask you, ma'am, if he wants to talk to that. You have it there, to try and answer your question properly, because this is his field.
I'll just clarify that paragraph 6 it begins what these statements do not provide us any context.
Yes, but it follows a lengthy quotation from the EIAR, I think.
So, Professor Hughes, do you wish to speak to that? I have read your statement, but happy to hear a discussion on this.
The benefits that are usually pointed to by developers as accruing to local communities usually come in the form of claims about jobs and other forms of income that will accrue to the community. The point that I'm making in this paragraph is that none of that arises if things aren't built. But I think it's also worth pointing out that the claims that are made about jobs are almost entirely, when examined in detail, that is in more detail given in the EIA, related to the construction of the development rather than to its ongoing operation, because its ongoing operation is largely outsourced and at a distance, and the only local jobs that would arise are for occasional maintenance and other related things. So that the practical impact on the locality from an economic point of view is close to zero once you are past the period of construction. The period of construction, on the other hand, as I think you will be told this evening, is usually extremely disruptive from the point of view of the local community. So in terms of maximising the benefits, which is what we're referring to, even if this goes ahead, those benefits are, in an economic terms, marginal, tiny, in a different way of saying it. And that will, and has been, that it will be the case for this development. It has consistently been the case for other developments in the Scottish Borders.
Thank you, Professor Hughes. Mr. Finlay? Or Mr. Kelly?
Thank you, ma'am. Just a couple of very small points to add. Basically, I agree with Dr. Ford, but we have no guidance on what it means to maximise net economic impact, and also being realistic in terms of contracts. The applicant is at the pre-consent stage, and therefore there is an obvious limitation in what they can enter into by way of contracts with people. But as offering some sympathy towards the applicant, my position is basically agreeing with Dr. Ford. I am not convinced that the net economic benefit has been maximised, as opposed to just having an economic impact assessment submitted.
Right. Thank you, Mr. Kelly. And Ms. Crawford?
I'll invite Mr. Littlejohn to address this matter, if I may.
Thank you, Mr. Littlejohn.
Yes, thank you. Good afternoon, ma'am. Yeah, I think in this policy context, we don't have any further comments to add in more around about criterion E, which relates to the Estomere array.
Thank you very much. Is it fair then, on my summarising the position in relation to Part C, to say that the applicant has done what they can to demonstrate economic benefit within the confines of current guidance that doesn't actually set out what maximising net economic impact actually is? Is that a fair comment to make? I'm presuming, Mr. Trinick, you're going to tell me yes.
Well, no, I'm not just going to say yes. I appreciate the points made by Mr. Ford and others that there is a matter of interpretation of this part of the policy. What does maximise actually mean? And there is that difficulty, and it's a difficulty for us as well as everybody else. That is in part why, as well as offering the usual construction benefits, which we all know about, we have actually offered the supply chain protocol condition to try to ensure that if the development proceeds, that the construction opportunities at a local level are maximised. That's all we can do. We can do our best.
Noted. Does anybody else have any comment on that, Dr. Ford?
My point is essentially that we're doing the same thing all the time, or we're not really moving this issue forward. At any point, somebody could actually resolve this issue, not just perhaps by the Scottish Government being clear about what they mean and defining the term, but actually a developer could come forward, and there's no reason why it couldn't be this developer, come forward to do something quite radical in terms of demonstrating absolutely clear that everything possible has been done to maximise the economic benefit. In that sense, I don't think the applicant has done that.
I suppose the difficulty with that is the word maximise, to my mind. You can demonstrate net economic benefit, but can you demonstrate to a finite degree that you have maximised net economic benefit. And in the absence of anything else, all we have is MPF4 in terms of policy, and we have to, certainly as a decision maker, I have to take MPF4 as it stands. If there are no other... Oh, Mr Kelly, and then Mr Campbell.
Sorry.
Just when I was listening to you there, ma'am, you used the word benefit, but that's not actually in the policy. What the policy says is maximise net economic impact. So strictly speaking, in terms of the English meaning of the words, that could mean they could maximise harm.
They could, but the policy then goes on to say including local and community socio-economic benefits. I think they would have to demonstrate both. If there was net economic harm, they would have to demonstrate where that would arise as well, if it was a consequence of their proposal.
Ma'am, it was a slightly flippant point, but I just wanted to make the point to you that it's not a well-worded policy in helping you make decisions or recommendations.
Thank you, Mr Kelly. Mr Campbell.
Yes, I was going to disagree with Mr Kelly's first, I think, jocular submission there, and I don't agree with it, but actually what you've got in front of you is a badly drafted sub-policy, because the keyword is not maximised, the keyword is only, and that suggests that your consent is, or should be, withheld, not your consent, minister's consent, should be withheld until they see actual maximised net economic benefit. So one has to have sympathy with the applicant, however much that may stick in your throat, because they have to, the best they can do is demonstrate potential economic benefit. And that requires you to read a word into the policy which isn't there. So it provides you, I'm afraid, with an exercise in semantics, which is quite difficult. And I think we should probably deal with it in closing submissions and not today.
I'm happy for this matter to be addressed in closing submissions by the parties. On that basis, just go back to my questions, I am going to move to Part D of MPF4 Policy 11, which is development proposals that impact on international or national designations will be assessed in relation to Policy 4, and in Policy 4, that's Criterion C, but are the parties in agreement that there are no impacts on national designations or international designations? And starting with Ms Sidgwick.
Sorry, ma'am. I don't believe that I think it's agreed that there are no impacts on international or national designations, both ecologically and land. I think there's a difference of agreement in respect of the ESA when it comes to cumulative issues. So I don't think...
Okay. Dr. Ford?
Agreed.
Mr. Campbell?
I'm just thinking about what Ms Sidgwick said there. Impact on national designations will be assessed in relation to Policy 4. If that has application at all here, it's on the landscape area designations. But I'm not going to offer you a reprise of this morning or yesterday, thank goodness. Again, I think it's a matter for submissions, because it simply says impact on. It doesn't say impact on beneficially or adversely or neutrally or anything. So it doesn't actually give you much help. Maybe you can have a sub-paragraph on the quality of drafting in your report to ministers, ma'am. But
unlikely, Mr. Campbell. Mr. Findlay.
Ma'am, nothing further to
or Mr. Kelly.
Nothing further to add, ma'am.
Mr. Littlejohn.
Yeah, thanks, ma'am. Again, nothing further to add.
Thank you. moving to Part E of MPF4 Policy 11, Part E sets out that, in addition to the previous criteria, project design and mitigation will demonstrate how the following impacts are addressed, and then we have a numbered list of different impacts to be considered. I'm not intending to go through every single one of them, you'll be relieved to know, but if we could begin, I think in terms of one, impacts on communities and individual dwellings, we have generally addressed quite a lot of that in terms of visual impact. We will be discussing conditions and noise specifically tomorrow, so I'm not intending to go into criteria 1 in any detail at all today. Moving straight to criteria 2, which is significant landscape and visual impacts, recognising that such impacts are to be expected for some forms of renewable energy. Where impacts are localised and or appropriate design mitigation has been applied, they will generally be considered acceptable. For those of you who attended the landscape and visual matters inquiry sessions yesterday and this morning, we did have some considerable discussion about the geographical extent of localised. I'm well aware that it is a difficult one to answer, but it would be useful if we could discuss it in the context of Greystone now. My question is, how should I understand the terms localised impact and appropriate design mitigation in the context of Part E criteria 2, and what implications does this criterion have to Greystone now? If we could start with Ms Sidgwick.
I seem to have been designated to answer this impossible question.
Mr Trinick, and I do appreciate the difficulty in answering this question, which has vexed many a reporter, many an applicant, many a council and many another party, but it would be useful to discuss it in the context of the specifics of Greystone now. So, Mr Trinick.
Yes, I mean, what does localised mean? Clearly, there is an issue of the geographic extent of significant effects. That's one element that feeds into the picture. Other elements of what localised means, I think, go to numerous inquiry decisions that are before you to see how the picture is building up of the way reporters address this particular word. What I take generally from the definitions I've read is that in addition to geographic extent, you need to look at the scale of the development and what might reasonably be expected in terms of the significant effects that arise from that scale of development. So a 2-turbine project may be expected to give rise to significant effects to a certain extent. A 50-turbine project can be expected to give rise to more significant effects, more geographically spread. So we have to take account of the scale of the development. I think also the type of landscape you're in goes into this mix, and I've seen that in 1 or 2 decisions, that clearly if you are in a very large-scale plateau landscape, you might expect effects to extend to a certain distance from a certain scale of project. If you're in other types of landscape, say, you might expect something rather different. And I'm not going to give evidence as to what, I'm just putting the factors. So I think geographic extent, scale of the development, and the type of landscape you're in are factors that go into the mix in coming to a conclusion. In terms of the application to Greystone now, ma'am, you have the evidence from Kelly Wilson. I don't think it's appropriate for me to give further evidence on the site-specific issue now, unless you really press me to do so.
Thank you, Mr Trinick. Dr Ford, the same question.
Well, in terms of localised, I mean, my view is that really, with 180-metre high turbines on quite a high hill relative to the surrounding residential property and the major thoroughfare and so on. I think the impact really spreads out effectively 2 to 3 kilometres. In other words, it includes the valley, the Gala Valley, and the A7 corridor. You're aware, Ma'am, in my submission I've given some specific numbers in terms of the impact and the amount of coverage on over the A7. We've also discussed elsewhere the residential impact. In terms of mitigation, the Council's position is, and has been consistently through this, that steps could have been taken in the application stage to mitigate significant effects of the proposal. That was proposed by the Council's landscape architect and was also revisited by the Council's appeal landscape architect. So there's an interesting consistency there. And to my mind, we haven't seen adequate mitigation from this proposal, which is fundamentally why we're here today. Thank you, Ma'am.
So do you consider, Dr. Ford, that should the mitigation that had been suggested by the Council's landscape architect and their expert witness, who didn't necessarily suggest mitigation herself but reflected the comments from the Council's landscape architect, do you think that that would have had an impact on whether or not the impacts are localised or otherwise?
It would have had an impact. It would certainly have reduced them. Whether it would have reduced them to the point of, if you like, removing the objection, I'm not sure about, Ma'am. That's a hypothetical situation.
Thank you, Dr. Ford. Mr. Campbell?
Ma'am, the predicate for this set of questions is in the beginning of subparagraph E. Talks about appropriate mitigation or localised effect. I have to say I found the applicant's response to your question very disappointing, because we didn't hear from Mr. Trinick a single word of original thinking in relation to what his team thinks about localisation, other than a reference to Kelly Anderson's evidence. Now, for the Council, you have in front of you a discrete chapter in its hearing statement for this session, electronic page 9 through to electronic page 11. And in that, the Council, the Community Council, offers a reference to the capacity study, recognising that it has been downgraded in status, and taking one at a time the criteria which might bear on the definition of localisation and expressing a view for you. So, from our point of view, we submit that we have done some original thinking on this very question. We haven't slavishly followed the ruminations of reporters in different parts of the country looking at different landscapes, but we have offered you a bespoke solution to this question for Greystone now. And that, in my submission, is the way we would expect to see an applicant do it, and they haven't done it.
Thank you, Mr. Kelly.
Basically, ma'am, I agree with Mr. Trinick, but subject to the caveat that it's not just about distance. And I addressed that this morning when paragraph 33 of my LVIA inquiry report was discussed. There are other factors other than distance, but basically I agree with Mr. Trinick, subject to that caveat.
Thank you, Mr. Kelly. Mr. Littlejohn?
Thank you, ma'am. Yes, we don't have any further comment on this criteria.
Thank you. If you just give me a moment to catch up with my notes. Turning to what Policy 11 doesn't address, that is tourism, unlike former Scottish planning policy. what, if anything, should I take from that? It does take us back slightly to our discussion on economic benefit, but I do note this question has arisen for me because a number of the original submissions questioned the impact on the tourist industry in and around Scottish borders, its relative importance and the potential impact that Greystone now may have. But noting that Policy 11 does not actually contain any reference to tourism.
Well, as I think you're probably aware, there's been quite a lot of research done in respect of the impact of onshore wind turbines on tourism, and as far as I'm aware, none of those have shown that there is any impact on tourism as a result of the construction and operation of onshore wind turbines. I'm not sure if that is referred to in the socio-economic chapter of the environmental report, but I can have a quick look and let you know of the EIAR.
Thank you, Ms Sedgwick. Dr Ford.
Can I just pick Ms Sedgwick up on one point? You're quite right. There's a lot of research on this subject, and you said none of it has shown any impact. With respect, that's not quite right. The research is actually showing that the results are inconclusive. That's because they're very difficult to measure. It's very difficult to measure whether somebody doesn't come back to an area because they don't like the wind turbines there, which is the direct impact, obviously. That's overstating it, perhaps. But essentially, the research doesn't show that there's no impact. It just is inconclusive about what the impact is, which is perhaps why it's not included in the policy, because actually it's a very difficult thing to, even more complex actually, in my belief, than actually looking at net economic impact. However, I do think we can take, if you like, an anecdotal picture on it, in the sense of, as I've said in my submission, ma'am, this is a major tourist route into the area. Tourism is very important to this region, and this proposal would be the first proposal to significantly impact on the A7 route into the area. Whereas the A68 is well covered with wind farms. So, you know, I appreciate you don't get any guidance in policy here, but and perhaps, as you say, it's to be measured in the light of the net economic impact. But personally, I do feel that there's a potential adverse tourism effect which should be taken account of. Thank you, ma'am.
May I just make one further observation? Just for your notes, really. Policy 29 is entitled Tourism. Yep. And, of course, it isn't dealing with the interaction of renewables and tourism per se. But Policy 29, and I'm talking about NPF4 again, little c. Sorry, I've lost place now. I beg your pardon, little b for Bravo. Development proposals in rural areas should be suitably scaled, sited and designed to be in keeping with the character of the area. That doesn't really take us any further forward. But just for your notes, there is a policy on that topic.
Sorry. Thank you, Mr Campbell. Mr Kelly?
Rachel is not putting forward any case in relation to tourism impacts, ma'am, so nothing to say.
Thank you. Mr Littlejohn?
Thanks, ma'am. Yes, likewise, we don't have any comment to offer on the topic.
Thank you. Mr Trinick?
Sorry, sir, not for the first time. I urge caution in receiving evidence from Mr Ford's counsel he represents. Make no tourism case in this inquiry. I ask you to note that. We have Mr Ford of his personal views, and to be fair, he said they are personal, but they're not the views of Scottish Border Council.
Dr Hughes, are you content that that's an accurate description of your previous comments?
One correction I would make is a professional view rather than personal view. I mean a professional capacity.
Noted. Right. Thank you all. Any other comments? No. I will then move to policy 3 of MPF4. Apologies for not doing these numerically, but it made more sense to me to do it this way. So if we could move back to policy 3, which is biodiversity. Again, apologies, I'll just get to my electronic page. So electronic page 39, actual page 38. A note from the EIA submissions of the applicant that the applicant is satisfied that the proposals go beyond mitigation and will restore and enhance biodiversity in accordance with policy 3. In general terms, I would like to know if the parties agree that is the case. I had expected somebody from the Scottish Ornithologists Club to be here today, but I don't think Mr. Parkinson has attended. He hasn't submitted a hearing statement, despite having indicated that he intended to do so. So I don't think we'll be moving any further in terms of this policy in ornithology. But in general terms, without going into the specifics, can the parties give me their views on whether or not the applicant's position is agreed with? Happy to start with, unless the applicant has any comment to make on that, but I don't think I'm mischaracterising your evidence. Okay, so if we move to Dr. Ford in the first instance.
I do agree, ma'am. I do think one thing worth pointing out here is that we don't really have guidance from Scottish Government about biodiversity. Biodiversity guidance and policy is well developed in England, and it's a real shame to see Scotland is quite a long way behind, particularly given that the other policies within MPF4, particularly reference to nature here. It's a shame, but that's not the applicant's fault at the end of the day, that we don't have real guidance to measure this properly.
Mr. Campbell?
The Community Council doesn't advance any case at all in relation to Policy 3. I draw your attention, quantum valia, to Policy 3 little b, which requires development proposals to demonstrate certain things. But it'll be for you whether you take that into account or not, and presumably a matter for my learned friends' submissions in due course.
Right. Thank you, Mr. Campbell. Mr. Kelly?
Rayshaw doesn't advance any case based on biodiversity, but I would agree with Dr. Ford that it's a challenge to us all to be presented with a very detailed policy like this and how to address it, though I think draft guide. So, but the basic point, ma'am, is we are not presenting a case in relation to the policy.
And Mr. Little?
Again, on this topic, we don't have any.
Right. Thank you all. Mr. Trinick?
Acknowledge what everybody says, and there's some truth. That is why development can't start until the habitat management and enhancement plan an update to better meet the HMEP the plan objectives. Enable people in this condition to take account of the circumstances future in this condition.
Thank you, Mr.
Information relative to policy 3B And just Mr Finlay and I are aware, this is by mitigation hierarchy. The name understand that there is an application court outstanding. I care to note that.
Thank you. Thank you.
I should just add that I'm not officially aware of any potential challenge any involved in it.
I'm not aware.
Let's see. Just returning to condition 16, can I take it that that is an agreed, without going to the schedule of agreed conditions, can I take it that is an agreed condition with Scottish Borders Council? Yep. Thank you. Unless any party has any specific comments on biodiversity or questions to put through me in relation to policy 3 of MPF 4, I am now going to move to policy 4 of MPF 4. That is page 40. Policy 4 is natural places, electronic, page 41. So, the policy itself in the green heading on the electronic version says at part A, development proposals which by virtue of type, location or scale will have an unacceptable impact on the natural environment will not be supported. What should I conclude in relation to this policy? Has the applicant demonstrated that there will not be, well, that's a double negative and Mr Campbell will be vexed, will the impact on the natural environment be acceptable as a consequence of Greystone now? Could I start with Ms Sidgwick for policy 4?
Yes.
Thank you. Dr Ford?
My understanding is yes.
Mr Campbell?
Yes, I want to relapse into double negative. I can't prove that it won't, so yes.
Right. Mr Kelly?
Again, ma'am, that is not part of the racial case.
And Mr Littlejohn?
Yeah, likewise, we don't have any comments up on the topic.
Right, thank you all. Moving to policy 4 part C, which is designated sites, the applicant concludes that part 1 of policy 4C is met by the proposal. Do the parties agree? I don't know if the applicant, clearly I've set out your position, you probably have no comment. No. Dr Ford, any contrary comment?
No.
Or comment at all?
No.
No, thank you. Mr Campbell?
The verb used in Part C is affect, again, without saying whether it's a beneficial or an adverse effect. We have tendered evidence in relation to the effect on special landscape areas. Yeah. So to that extent, that is our answer.
Thank you, Mr Campbell. Mr Kelly?
Again, ma'am, it's not part of our Bishaw's case.
And Mr Littlejohn?
Yes, again, just to confirm, we don't have any comment to offer on the topic.
Lovely, thank you. And back to Mr Trinick.
Just address Mr Campbell through you. I think you're really talking about 4D and not 4C in terms of the SLA. I'm not sure that you have a case under 4C.
Yes, you're quite correct. I'm sorry for not noticing that. You're quite correct.
Okay, noted. Thank you. You will now be disappointed, Mr Campbell, because I didn't have any questions in relation to Part D of Policy 4 and was going to move entirely to Part E with a very general question. But if you do have any comments to make on Part D of Policy 4, MPF 4, I'm happy to hear them now.
It was the right answer. It's just in relation to the wrong section. So.
Noted. I was trying to think of a double negative to respond to. Failed.
Can we stop this game?
Yeah, absolutely.
I don't have further comments on Part D. Thank you very much.
Thank you.
Other than those made already.
Ms Sidgwick, were you going to interject?
No, nothing to add, thank you.
Thank you. I'll just make my... Part E of Policy 4 relates to the precautionary principle and says the precautionary principle will be applied in accordance with relevant legislation and Scottish Government guidance. That is a fairly broad criterion, and I am wondering how reference to the precautionary principle should be understood in this particular case. Is there anything of particular relevance you consider I should have regard to? That's to the applicant in the first instance.
It's a very general paragraph, difficult to... Uncertain here.
Thank you, Mr Trinick. Dr Ford.
I tend to treat it as a backstop to the other policies and the other details, if you like, Ma'am. So it's a principle rather than a particular policy, but I agree with Mr Trinick.
Mr Campbell, any comment?
No comment at all.
Thank you. Mr Kelly?
Nothing to add, no.
And Mr Littlejohn?
Yes, thank you. No comment.
Thank you. Moving to Part F of Policy 4, MPF 4, I could read you the entire paragraph, but I'm not going to. In effect, it relates to the level of protected, or the effect on protected species, and if that effect is adverse, it sets out the level of protection required by legislation which has to be factored into the planning and design of the proposed development, and that the potential impacts have to be fully considered prior to the determination of any application. Do the parties agree that all and any protected species on the site have been identified and any potential impacts have been fully considered? If there isn't a contrary view, I'm quite happy to move to everybody to simply confirm that to me.
I can confirm that for us.
Thank you.
Confirm, Mum.
Thank you. Mr. Campbell?
I might have wanted to talk to you about Golden Eagle, but there's no case made, so I won't. So the answer is no. Thank you.
The Scottish Ornithologists Club had indicated they intended to speak to raptors, but we haven't, as I said earlier, we haven't had a hearing statement or attendance by that person, so we don't have the benefit of that evidence. So, Mr. Kelly, any contrary view?
No contrary view, ma'am.
Thank you. Mr. Littlejohn?
Yes, thank you. No comment to make. Thanks.
Thank you very much. That concludes my questions on MPF4. I'm at risk of repeating myself, but your hearing statements were comprehensive on MPF4, and really those were the only questions arising which I needed to ask to aid me in preparing my report. I will move quite briefly to the Scottish Borders Local Development Plan 2, which has been adopted, and CD 6. The relevant policy ED9, well, it's the same policy reference, it is a different policy. The question in to does the adoption change to the overall development plan policy Scottish Borders?
I think it does to a certain extent because it makes the direct reference to MPF4. And in considering renewable energy developments, it's very clear from the policy that there is general support for all forms of renewable energy, low carbon, zero emissions technologies, and then it goes on to say development proposals will be assessed in accordance with MPF4 Policy 11, paragraphs B to F, and other relevant provisions of MPF4, which is not in the previous version, obviously, because it was well in advance of MPF4.
Okay. Dr. Ford.
I don't believe it makes any substantive change, ma'am.
Thank you. And Mr. Campbell?
No, we don't think it makes any difference. I think I've dealt with this in the hearing statement.
Yes. Mr. Kelly?
No, I agree it makes no difference, ma'am.
Okay. And Mr. Littlejohn?
Ma'am, I wonder if I might interject at this stage and,
Indeed.
At the risk of being accused of being a politician, not answering Ma'am's question, the MOD does wonder whether you would wish some discussion relative to Policy 11E(4), or whether you're content that that be addressed at tomorrow's condition session. And of course that deals with demonstration of the impact on the Estailmuir seismic area.
I am happy to discuss that in relation to MPF4 and policy, if the evidence will be different to the discussion we're going to have tomorrow on conditions. If you think it will, I am very happy to hear evidence from the MOD today.
Well, that's very helpful. I'm not sure when you would think it appropriate to do so, because I'm aware we've moved into discussion of LDP2. So
To be honest, Ms Crawford, that was my only question on LDP2.
All right. Well, that being so, with your leave, I would, and obviously subject to the applicant and others, I would be grateful if Mr Littlejohn could just express his views relative to that criterion in Policy 11.
No, I'm content with that. I think it would be a useful point at which to hear that evidence. So, Mr Littlejohn, for the purposes of those attending and those watching on the webcast, we're looking at MPF 4 Policy 11, Part E, Criterion 4, which is impacts on aviation and defence interests, including seismological reporting. And the MOD evidence is specific to Eskdale Muir seismic array in this instance. So, Mr Littlejohn, would you like to lead?
Yeah, thank you, ma'am. And that's exactly right. I think the MOD's position is that much of this might be discussed in the conditions session tomorrow, but in the policy context, I think we're keen to make the point around about that reference to the protection of the array. And on that basis, I think that there is agreement, I think, with the parties that the policy context does seek to protect against impacts on the array and consideration around about any necessary mitigations. But we were keen to make the point that there is an in-principle objection from the MOD in terms of impacts on the array, and taking that a step further, an in-principle constraint, the MOD's view is, to this development coming forward. Briefly stated, we were keen to make the point in the policy context that we do not know when or indeed if such a constraint will be resolved, nor indeed do we know anything around any potential mitigations required to ultimately satisfy that test within that criteria of the NPF. To my mind, and taking it back to a planning consideration, the NPF references around about mitigation must surely reflect those that, from a town planning sense, address impacts that we know about, impacts that are tangible, and not those that we cannot know at this stage, or indeed whether they can be resolved until the research, obviously in this case, is concluded, which we refer to in the MOD's statement of case. And it was to make that point in the policy context that fairly significant ambiguity to the MOD's mind to their precautionary approach to the safeguarding of the array. So, as I say, I think we felt it was important to make that point known in the context of the policy consideration prior to going into the session tomorrow on conditions.
And I wonder if I might just add to
Thank
that.
you. Yep.
If one looks to the wording of the policy, it's demonstration how the impacts are addressed relative to seismological recording reading short. And it respectfully seems to the MOD that that demonstration is proffered by reference to let's see what will happen. And with respect, it does seem to us that that is not what one would conventionally understand in the planning context as mitigation. Wait and see does not equal reducing, avoiding, restoration or reset. Just to, I think it is useful to make these remarks as context to tomorrow's session on the conditions.
Thank you both. I have a question which you might or might not be able to answer. In the context of Scotland nationally, are there other defence interests which include seismological recording?
Not so far as I'm aware. No. Those behind me, no more, no.
Okay, thank you. Would the applicant like to respond?
Only briefly. We'll tell it tomorrow. Technical mitigation. We don't believe it's appropriate being developed. a suspensive condition, as you know. I don't want to add any more now. We'll deal with it tomorrow.
I know we will be discussing this in much more detail tomorrow, but does any other party have any comment on the matter before I move on? Nope. Okay, thank you very much. I think that draws to a conclusion my questions on MPF 4. I had some general questions about achieving a planning balance and weighing benefits against adverse effects, but I think given the discussions we've had to date and our discussions which will take place tomorrow and your comprehensive hearing statements, I'm happy to rest my specific questions there. I have on the agenda any other relevant matters, and it may be that now is a good time to discuss potential accompanied site visits, or at least to the extent that we can before we hear noise evidence tomorrow. That may add to an itinerary. I'll begin by saying I am very content to do accompanied site visits. I have carried out unaccompanied site visits, but I can see where accompanied site visits may be of benefit to most parties. As is traditional, we would ask the applicant to devise an itinerary if I give an indication of locations I would wish to see on an accompanied basis. We have spoken about a nighttime visit to perhaps another operational wind farm so we could view similar or comparable nighttime aviation lighting. Has there been any advance on that, Mr. Trinick or Ms. Sidgwick, that we could factor in something that's reasonable for people to get to?
First of all, we don't think, we leave it to you to decide whether or not viewpoints. But I think the accompanied site visit is required, and that is to examine the residential visual amenity aspect, which is between us and Heriot Council, and you will need to go onto private land to do that, so you will need to be accompanied. So that's well, it may be more than two properties, but whichever property Heriot Council wish you to see, you should visit.
Yes, I have. My site visits to date have been in the vicinity of the residential properties identified in the various submissions. I haven't actually been into the properties or on the property, I should emphasise. I note that your landscape witness this morning identified 2 and potentially 3 residential properties. Are there, obviously there are more that have been assessed, but are those 3 the ones that you would wish me to visit?
Deal with that.
Okay.
Yes, I think she was identifying properties in Fleming's Place, I believe. Is that correct?
And also at Corsup.
And Corsup, the properties there. I would also like to, for you to do an accompanied visit to some of the other viewpoints. Crookston would be one, which I would like to show you. Netling Flat would be another. And then Lauder Common. I would have comments to make at all places about what is likely to happen and the likely cumulative effects.
The issue with that, Mr. Williams, is on accompanied site visits, it won't be possible to make any comment to me that would constitute evidence. I would simply be looking at the physical aspects of the viewpoint or the...
Yeah, I just meant that I would be drawing your attention to the various wireframes and potential views. No?
That won't be possible, given the way that accompanied site visits work. I already have the benefit of the wireframes and your views and your witnesses' views on those. So the purpose of the site visit is for me to be assured that I fully appreciate the physical aspects. I would tell you that I have already been to Lauder Common, Netling Flat and Crookston, and I'm content that I have seen enough there. Where I'm not content is in relation to specific residential properties, and I'm very keen to spend a bit of time in appreciating views and impacts from specific residential proprities.
Very well. I will arrange to take you into some of the appropriate properties.
Can I suggest a solution to this?
You can, of course.
I think Mr. Williams does know the rules about accompanied site inspections.
Good.
If he pauses for a second. But what I would propose is that we come tomorrow morning with a list of properties we'd like you to visit, having tried to clear those with the applicants overnight. Would that be satisfactory?
That would be appreciated.
Yes.
Can I just double check? Is Fleming Place in Fountain Hall Village?
Yes.
Yes. Right. I know the location you're talking about. Yep, that would be appreciated. Do we have a date in mind, or is that a step too far at this stage?
No, it's up to you.
Okay. I will give some thought to when that could work. If there are any absolutely unavailable dates, or if there is a date that is particularly convenient for parties, please let Christine, the case officer, know as soon as possible. The light is not superb this time of year, so we won't have a full day, but I would think 10 until 4 is perfectly adequate to visit. These are not far-flung locations. We can absolutely visit everybody in a day. So the logistics of that are capable of being resolved. I'm content with that. Okay, Mr. Campbell, we'll have that list from you tomorrow. If following the noise session tomorrow afternoon we need to add any to that, we can do so at that point.
Could I ask you, when you talk about going to properties, are you really talking about standing in the garden and looking outwards, or are you talking about entering the properties and looking out from the interiors? Or
well, depending on the list you give me and revisiting the assessment of those properties, which has already been carried out by the applicant, I'll be keen to look at primary views, which could be from living rooms or kitchen areas, also primary views and orientation of garden space, etc. All of those are referenced already, so that in particular is what I haven't. I have stood outside properties on roads, but I haven't had the benefit of experiencing what a resident might. So that would be my intention, is to gain that experience. So yes, is my short answer.
That's helpful. I think really this should have been done before now, and I'm sorry it hasn't been.
Mr. Trenick.
Ma'am, you asked me to deal with the night visit as well. The difficulty is trying to find a wind farm with lighting which is modern lighting, which has got automatic dimming from 2000 candela to 200 candela. You need to be able to see the automatic dimming if it's operating. We do have one wind farm called Crossdykes, which may be the right one to visit because we know it's got automatic dimming. We don't have the full technical specification of the lighting. It's notoriously difficult to get hold of. But that's our current suggestion, which I put out in the inquiry in case there are comments on that.
Do you know the location of Crossdykes? Is that in Fife?
No. It's either in Borders or South Lanark, I'm not sure.
Ma'am, Crossdykes was suggested last week at Breakery as a suitable site for that reporter to visit. I'll need to check my notes. Mr. Hardy, the advocate in that case, was to confirm to your colleague that the lighting was operating properly to specification. And so, subject to that, I'd be happy with Crossdyke. As was similarly discussed in Crossdyke in Breakery last week, ma'am, the position of Rayshaw is that your nighttime visit can be unaccompanied. We don't seek any form of accompanied visit to inspect that lighting. In fact, overall, Rayshaw is content that you undertake your site visit work yourself.
Subject to, I am aware of the technical difficulties that have been encountered with operational aviation lighting. So I'm happy to do an unaccompanied site visit, but would require technical assurance before I head off that what I am looking at is the appropriate candela level. So if that could be, I hesitate to say categoric, but enough to give me comfort that what I am looking at is what I should be looking at. Very happy to do that on an unaccompanied basis.
It's east of Lockerbie.
Well, so Mr. Trinick, you're going to provide me with the specifics of cross dikes, and then we will take it from there. I will let you know when I'm doing it, but it will be on an unaccompanied basis. Are there any other relevant matters that any party wishes to raise at this point in time in relation to energy and planning policy and this hearing session?
No, thank you, ma'am.
No, ma'am, but before you close today, could I raise closing submissions, as I won't be here tomorrow?
Yes, indeed, you can.
It's really just a question of timetable.
I didn't have my microphone on, apologies. Did you hear all of that? That is half term. So it's half term in Scotland, which...
It's half term in part of Scotland, it's not half term in the border.
Oh, good Lord. Right.
It's in Edinburgh and East Lothian, which perhaps affects more people in this room.
It is. Is the 13th of February still convenient for the Council and other parties? Yeah. That's 2 weeks after the end of the oral process.
I'm afraid it's not. I would indent for Monday the 17th, please.
Is there... I'm trying to find my calendar.
Gives the weekend for writing, which Friday the 13th, oh, sorry, Thursday the 13th doesn't. I just have a full diary, and I'm not sure I can manage the 13th.
Well, unless anybody has any objection, Monday the 17th is acceptable to me. Mr. Finlay, does that suit you?
That's Monday the 17th is fine, and it leaves Friday the 14th free for other matters.
Well, that then would change the applicant's closing submission date, which originally had been in as the 27th. I'm just going to get my diary. So, Monday the 3rd of March for the applicant's closing submissions. I will get Christine to email you all the template, should you wish to use it. You're not confined to the template, but I would urge you to use it as far as possible. It is entirely to my benefit for you to do so, and ultimately perhaps yours. Any other relevant matters?
To backtrack a little, if I may, I brought Professor Hughes here today in relation to his paper on socioeconomics, which is in front of you. You haven't asked him any questions directly about that. Could I ask politely if you have any such questions? He's here to respond to them.
I did, and I appreciate his attendance. I do think it was comprehensive, and I understood all of it and the points that he made. So apart from the more general question on economic impacts, I didn't have any specific questions for Mr. Hughes in relation to this matter.
I was just ticking that off. If you're happy, then that's fine.
Thank you. So, moving to my closing remarks in relation to this hearing session, it simply remains for me to thank you all for your participation and input today. It is invaluable and will help me in reaching my report recommendations to ministers. The next step in the process is some of you will be seeing me later this evening at the community session at the Station House in Stowe. That is from 7 to 9 p.m. this evening. It will be webcast live, so if you can't attend, you may watch it live. It will also be recorded, so from pretty much tomorrow morning, you will actually be able to see a recording of that session, should you so wish. If you are not attending the community hearing this evening, we are reconvening tomorrow morning to have our conditions hearing session. There is an agreed schedule of conditions between the applicant and Scottish Borders Council, so a number of the matters that I had put on the agenda now don't need to be discussed, but we'll very briefly confirm that tomorrow and tick them off. I anticipate the majority of the morning will be spent discussing MOD interests and how those are addressed by this development proposal, and the potential for a suspensive condition and the implications of that moving forward. So, in the afternoon tomorrow, we will be addressing noise, and then the oral part of this inquiry will come to an end. Could we start at 9:30 tomorrow morning rather than 10 a.m? It simply gives us more time to address matters. It also gives us a little bit of room should we require it later in the day. Is that acceptable to everybody, or is it a difficulty for any party? No? Good. Well, again, thank you very much for your attendance and your input today. And I have mentioned it more than once, but I would say the quality and comprehensiveness of your hearing statements has meant that my questions are actually quite limited, which is always welcome in a hearing session. Thank you again, and I shall see some of you later this evening and more of you tomorrow morning. Thank you.